This afternoon session is very, very important to score a good mark in HR and HR legal. First session is the schedule is like this: CDA rules and misconducts. Misconducts calculation, that is decrement of one increment, decrement temporarily for one increment for 2 years. So those portions will be taken care by me for another 1 hour. So 2:15 to 3:15. After 3:15, we will go for gratuity, pension, and family pension. For features of pension, family pension, and calculation, how the formulas for scheme and act is working, and working rules for gratuity and pension. We will go through that. It is up to 4:15. From 4:15 to 5:15, we will review the question bank answers. I will show you the actual questions which were shown previously by the previous year examinations. So those questions you try to answer one by one. Then it will be okay. Then you will come to know what is the question pattern. But unfortunately, I'm not able to make ready for scale 1 to 2, 2 to 3, 3 to 4. So it is a combined questions. Maybe one question may be very easy, but one question may be moderate, and some other questions may be a little bit tough. So like that, I have prepared. Try to answer those questions. Then we will have an open session for some more doubts. Until you see all the questions, MCQ questions, then it will be okay. I think 50% of your query will be answered in the questions itself, answers itself. Then we will have a question answer session. Then we will wind up the session. So today, this is the program. But CDA rules, this one is very important aspect. You can aim around 5 to 6 questions on CDA rules. What is misconduct? How the rules are there? What is the rule number? In certain years, the rule number has been asked, 16A. But there are very familiar rules. Form number 16, rule number 16A, submission of property returns, and gift, limited of acceptance of gift, then suspension. So like that it will go. We will go one by one. This is conduct and discipline appeal rules of the GIEAIA company. There was introduction after 2014. 2014, a major amendment in CDA rules came. Originally, it was in 1972, 1973. And after that, a major amendment came only in 2014. After that, several amendments, I think 5 to 6 amendments came. One is that the board subcommittee as appellate and memorial authorities, and sharing of computer password, e-crime, sexual harassment at workplace, and the influence of narcotics and drugs. They were included as misconduct. And limit of acceptance, previously it was a very small amount, 500 to 1,000, like that. But now it is increased to 10,000, and personal front 7,000, other cases 5,000. A review of suspension order once in 6 months. Previously, this provision was not there. And the suspended employee shall have the right for increase in subsistence allowance immediately after 6 months. This was a new provision. Reduction to a lower scale and time scale for a period not exceeding 3 years included as minor penalty. Then wording of dismissal, very important. Wording of dismissal under major penalty changed to dismissal, which shall ordinarily be a disqualification for future. We will not, the dismissed employee will not get any future employment elsewhere. So under major penalty, that was revised. And revision in schedule, that is who is discipline authority, who is appellate authority, who is memorial authority, some revision was there. So this is the nutshell in CDA rules. Each company has CDA rules, but all are equal, because GIEAIA has made it the common CDA rules, and it was adopted by our company, respective company, and it was approved by the board, so that all the rules, regulations, conduct, suspension rules, everything is common for all the company. Normally, rule 2 will see the definitions. What is an act? Who is the competent authority? What is misconduct? So like that, the rule will go. Rule number 2 will go. But the CDA rule, one more very important point is, it is applicable for all the employees who are governed by the pension scheme, and amendments there to the extent provided under the scheme. So that's why Even for retired officials also, this CDA rule is applicable because it is coming under applicable to persons governed by the General Employees Pension Scheme 1995 and amendments thereafter. So for retired employees also, this CDA rule is applicable. So that you must note. I will highlight the important questions which were usually asked and which will be asked in the future, in the coming months. I will just tell you, just note down it. And in case of any doubt, you can ask at the conclusion of the forum. So rule number 3 states about the general, every employee shall what is maintain absolute integrity, devotion to duty, do nothing, become an unpublic servant. All are the public servants. So we should not act as an unbecoming a public servant. And you should maintain the absolute integrity, devotion to duty. So these are all the rule number 3. This rule number 4 is important point, misconduct. What are all the misconduct under CDA rules under rule number 4? Theft, fraud, dishonesty. If any employee committed any theft, fraud or dishonesty, then under rule number 4, this employee have to face the consequences, either domestic inquiry and punishment thereafter, depending on the veracity of the theft or fraud committed. Taking bribes or illegal gratification, possession of pecuniary resources and property. These are just simple English words only. Furnishing false information. This is very important. Suppose furnishing false information comes, your date of birth is one date, and as per birth certificate, you have joined in the company. Your SSLC book and college certificates also specify the same date of birth. Suppose you are applying for a passport and applying for a foreign assignment in our company. In that, after 20 years or 30 years, the HRM department comes to note there is a different date of birth in passport. If that being the case, why it has come? Why he has mentioned at the time of joining in the G17 form, the one date of birth, but in passport, there is another date of birth, which is a real one. So they have furnished a wrong information about the date of birth. In that aspect, the disciplinary authority may issue a notice. Subsequently, charge sheet can be issued and domestic inquiry may be conducted to find out the real cause of the false information given by the employee. And if it is found, the original date of birth is mentioned in the passport and the date submitted here is false information. Like that, if it comes to know or it is proved, then the employee has to face the punishment and are mentioned in the CDA rules. So that is one false information, not only date of birth. False information means there is a father's name, mother name, degree for graduation completed, any information. Then one more thing is sleeping while on duty. This question has been asked several times. Sleeping while on duty is one of the misconduct. They will ask like this. One of the following statement in CDA rules is false one. Sleeping whilst on duty is a correct one. So they will give some wrong answer. You have to identify which one is wrong. Commission of any act amounts to criminal act involving moral turpitude. Very important is absence from the employee's appointed place of work without permission or sufficient cause. This question has been asked several times, 4 or 5 times. In case of absence from headquarters, you have to intimate to your superior. If you are an officer, inform your in charge. If you are working in a regional office, inform your CRM or DGM that I will not be available in headquarters from this date to this date. This conduct is also very important. Smoking within premises of the establishment where it is prohibited. The 1, 2, 3 are very important. Sleeping whilst on duty, absence from employees' working place, smoking within premises, then purchasing properties, machineries. You have to inform to the company, and this will come under Form 16. What are all the purchases involved? What are all the sales involved? The statement 1.4 will tell you what is the assets and liabilities purchased and sold. Commission of any act subversive of discipline or good behavior. Abatement of our attempt of abatement of any act which amounts to misconduct. This is very important. Sharing of computer password. You should not share your computer password. While working in the computer, you have to enter your password and you should not enter others' password and enter in the computer. And also, the person should not reveal the password to the another employee. So that is a misconduct under CDA rule. Wrongful illegal activity committed through use of computer, internet. Through internet and computer, any violated illegal activity has been done, it will attract punishment under CDA rule. Indulging of any sexual harassment of women at workplace, possession of consuming of influence of narcotics or drugs, even alcohol is also prohibited, the misconduct rule. So those are all misconduct under rule number 4. One of the questions may be asked like this. One of the following is not a misconduct under rule number 4. So you have to identify which one is not spelled in the misconduct. You have to identify that one. So rule 5, scope of employee service is 24/7. It is not restricted to office time. All employees must, his service is required 24/7. Employees not to seek outside employment, including honorary, without the permission of the higher official. If you are making a honorary visit to some colleges or some companies, you have to get permission. If you are working, you have to get permission from your department head so that he will allow, and then you can get the honorarium also from that particular institution. Part-time work after office hours should not be done. So that's why that NPA allowance for doctors that was withdrawn. Obligation to maintain secrecy during service or retirement or resignation. Even after retirement also, you should not reveal the secrecy of the company. Evidence before committee or any other authority. Prohibition against participation in politics and contesting by election by filing nomination. If you're an employee, you have to first resign from the company and then only you have to file the nomination and participation in politics. Rule number 10. You have to remember the rule number and what it says. So rule number 10. Rule number 11, participation in demonstration, connection with press and radio. Prior permission has to be obtained from the competent authority. This is very, very important. Almost every year this question has been asked. Rule number 13, acceptance of gift. Gift shall include free transport, boarding, lodging. So this is also free transport, boarding and lodging is also a gift. Gift from relatives, there is a limit, 10,000. Personal friends, there is a limit, 7,000. And others, there is a limit, 5,000. If from same person, gift received is more than once in a time, you should inform the competent authority if aggregate value is more than 5,000. If aggregate value is more than 5,000, then you have to inform the competent authority that I have accepted gift from this person to this person and the amount is so and so in a closed cover, or through some mail, you can inform to the competent authority, that is to your higher official. This is very important. Note down the amount, 10,000, 7,000, 5,000. Aggregate amount, if it exceeds 5,000, you should inform to the competent authority. This is very important question. Speculation in stocks and shares. You should not speculate, but you can transact. You can purchase share, you can sell shares, but not frequently. Frequent purchase and sales will attract speculation and you will gain or you may lose some amount, very good amount. So for that, speculation is prohibited as per rule number 15, but you can purchase, you can sell the shares for investment and you can sell for some marriage or some school education fee like that, you can sell. Restrictions on borrowing and investments. This red mark is very important. Frequently asked question, FAQ. Submission of property returns, immovable property exceeds 2 months basic salary. Remember, immovable property, 2 months basic salary, annual return before 30th April, transaction above 2 months basic salary to be reported within 30 days to the competent authority. That is, this is immovable property. More than 2 months basic. Suppose your basic is 50,000 rupees. And if you are purchasing an immovable property for 1 lakh, then you have to inform to the higher official, your competent authority. So this is my purchase. That is under statement, I think 1 or 2 will be there. You have to inform before the reported within 30 days to the competent authority. Similarly, if you sold this property after some 2-3 years, then you have to inform to the competent authority. 17, not so important. 16A is very, very important. Rule number 16, 16A. Meaning of debt, total liabilities exceed 6 months basic salary. The meaning of debt under CDA rules is as follows. Total liabilities exceeds if your 6 months basic salary, not DA, not gross, only 6 months basic, then you will be considered as debt under CDA rules. Rule number 18, employees not to be absent from duty without prior permission. Almost all years this question has been asked. Almost all years. Maybe 1 or 2 years they omitted this question. 1 day CL without prior permission is allowed. Employee not to be absent for duty without prior permission or be late in attendance. This phrase, this rule is very, very important on examination point of view. 19, important. No employee shall absent himself from his station overnight without prior sanction. 18, 19, important. Rule number 20, very, very important. What is suspension? What is suspension? An employee may place an employee under suspension. An appropriate authority. Who is appropriate authority? We will see. Appropriate authority may place an employee under suspension under the following circumstances. This 1, 2, 3 rule is very, very important. Disciplinary proceedings against him is contemplated or is pending. Criminal offense is under investigation or trial. Detained in custody, whether or a criminal charge or otherwise for a period exceeding 48 hours, deemed suspension from the date of detention. Very, very important. Almost you can expect a question on this suspension. This rule, disciplinary proceeding against him is contemplated. Criminal offense is under trial or investigation, and he is put. It is deemed suspension from the date of detention. What is suspension? We have seen. Who is the appropriate authority? Appropriate authority is normally disciplinary authority is different. Appropriate authority in case of suspension, normally the regional office, regional in charge, after consulting with head office, will inform to the divisional manager or branch manager that so-and-so employee, because of the misconduct committed last week from this date to this date, the appropriate authority at head office, as normally GMP or DGMP will be the appropriate authority. They will tell he should be under suspension until the investigations and the proceedings are over. Then the DM or BM can issue the suspension order to the concerned employee, because since he is suspended, he cannot invade into the office and suppress some materials which are available, which are favorable to him. So that is the purpose of suspension under rule number 20. A suspended employee is suspended. In some period, they will mention 3 months. In some order, they will not mention the date. So in that case, he will not get the salary because he is not coming to the office. No. So there is a provision under CDA rules, under rule number 21. Rule number is very important. Rule number 20 suspension, 21 subsistence allowance. What is this allowance? 50% of monthly emoluments comprising basic pay, DA, CCA, HRA, qualification pay, personal pay, special pay, and deputation allowance shall on the date of immediately prior to the date on which the employee is suspended. So 50% on these factors can be granted to the employee who is under suspension. But of course, while releasing this amount, you have to take care of the normal deductions also. PF, LIC, Mediclaim premium, some other deductions, cooperative society, some other deduction should be there. Deduct those amount and pay the remaining amount only to the suspended employee. So that is subsistence allowance. What are all the factors taking into account? So you have to remember basic, TA, CCA, even FPA also. If FPA is there, FPA can also include HRA, CCA, qualification pay, personal pay, special allowance also, deputation allowance also included. This allowance vary after 6 months. Suppose employee is suspended, inquiry is going on, it is not completed. If the inquiry is conducted because of the fault of the management, because management has not completed the inquiry within the time schedule. In that case, his subsistence allowance will be increased to 75%. One case. Second case, if the employee is not coming to the inquiry, he is absent. He is not coming. He is telling, I am not sick, I am out of station. Such that if it prolongs like that, and if more than 6 months is over, management has the decision to reduce the subsistence allowance to 25%. So that are the two concepts. Increase to 75% if the reasons for the delay is not attributed to the employee, and reduce to 25% the reason is directly attributed to the employee. So these are all the next provision. That is, after 6 months, if it is fault of management, it can be increased. If it is fault of the employee, charge-sheeted employee, then it can be reduced. Because unless if you get 50%, he will go on dragging the schedule inquiry. So immediately we will reduce to 25%, but not lesser than 25%. So this is one point, very important point. No subsistence allowance during the period of detention by the police. Suppose if he is under the jail or behind the bars, no allowance will be paid, no subsistence allowance will be paid. And rule number 2021, appropriate authority shall mean authority competent to impose major penalty. Who is the appropriate authority means who is the disciplinary authority or appointing authority, whichever case. Suppose if he is terminated, in that case, appointing authority is the appropriate authority. Some punishment is given so that in the schedule, at the end of the slide, I will show you some schedule. In that, disciplinary authority will be mentioned. So he is the authority for taking appropriate authority, and he will impose the major penalty. Compulsory deductions. This has to be taken care, I have told. Voluntary deductions, LIC premium, society, loan taken from PF, this has to be deducted from the 50%. No deductions towards PF amount due under court attachment, recovery of any loss which may be caused to the company. So this amount towards PF amount due under court attachment has to be deducted. This is also to be deducted. Very important slide. Rule number 22 says treatment of period of suspension. 20 important, 21 important, 22 important. Any period of absence which has not been treated as spent on duty or on leave shall not count for service for any purpose, but it will not constitute as break in service. Refund of subsistence allowance by the employee cannot be done. Treatment of period of suspension. Any period of absence which has not been treated as period spent on duty. Suppose at the final inquiry, if it is proved that the employee is not at fault, some other employees are fault, this employee is not fault, then everything will be revoked. Suspension period will be revoked. It will be treated as continuous service. The balance amount of 50% will be given to the employee. Everything will be restored. On the other hand, if the employee is found guilty and the employee is imposed some punishment, minor punishment or major punishment, then this suspension will be constituted as a break in service, and no refund of balance 50% will be given to the employee. So this is main aspect, treatment of period of suspension. Rule number 23, penalty. Which penalty has to be imposed? Only the mentioned penalty has to be imposed, not any other penalty. One, this is some minor penalty. Censure. Censure means some warning letter. Suppose if it is mentioned warning letter, this is not a minor penalty. Only censure is a minor penalty, but it has a wording. It has a legal effect on the person's promotion and other aspects. So censure, even though it is a warning letter, if it is mentioned in the examination paper, warning letter is whether it is a minor penalty, it is no. Censure only is a minor penalty. Withholding of one or more increment for a specified period. Withholding is increment for 1 year. Withholding is increment for 2 years. After that, it will be restored. So that is the point here. It is only temporary. It is only temporary withholding, not permanent. Recovery of whole or pecuniary loss caused to the company by negligence or breach of orders from pay amount as may be due to him. Suppose if someone he has made because of his negligence, he has some pecuniary loss has been committed to the company, that amount has to be recovered from that concerned person. Reduction to a lower stage in the time scale for a period not exceeding 3 years without cumulative effect. Cumulative effect means it is continuous. but without cumulative effect means it will be restored after 3 years. So these are all some minor penalties mentioned in the CDA rules under rule number 23. 1, 2, 3, 4. Very important. Just memorize these penalties. Major penalty. This is also important. Withholding of one or more increment permanently. There is a difference. There I will withhold for 1 year. After 1 year, I will release the normal increment plus withholded increment. But here, I will not release the increment for 1 year. Next year, he has to forego one increment. And from next year, he will get the only normal increment, not the stopped increment. So that is the difference. Reduction to a lower post, lower time scale, lower stage in a time scale, compulsory retirement, removal from service, which shall not be disqualification for future employment, dismissal from service, which shall ordinarily be disqualification for future employment. So these points are, this is termination. These are all termination, which is not a disqualification for future employment. Dismissal, a disqualification for future employment. So these are all the major penalties under CDA rules. They will give one major penalty, which is a false statement, which is a correct statement. Which one is false, which one is correct, you have to mention. See, this is also important. Withholding of increment, normal increment for unsatisfactory work. Stoppage of employee at the efficiency bar, that is stagnation increment. Non-promotion, reversion to a lower grade or post of an employee officiating in a higher grade or post. Reversion on probation. Termination of employee appointed on probation, temporary capacity, etc. These will not constitute penalty. These are all normal terms and conditions of the appointment order. They will give reversion on probation, termination of employee appointed on probation. Whether these are penalty? No, these are all not penalties, either minor penalty nor a major penalty. So this will be excluded from penalty list. Similarly, warning letter. Warning letter is just a caution letter, but censure letter is had some effect on his future promotion and increment on stagnation. Remember this. This will not constitute penalty. So disciplinary authority, we will see the schedule. Procedure for imposing major penalty only after inquiry. So without making an inquiry, inquiry means departmental inquiry. For departmental inquiry, first, if the employee found guilty, or suppose if any financial irregularity has been done by the particular employee or cashier or accounts officer, then first the vigilance officer will come and investigate the matter. If the investigation proves that there is a prima facie, there is an evidence that he is made such crime or such financial irregularity, then he will report to the matter to the concerned head office department, and that IDD department or HR department will appoint disciplinary authority to look into the domestic inquiry. Disciplinary authority will nominate inquiry officer and presenting officer to conduct the cases, and inquiry officer and disciplinary officer will coordinate and they will issue a charge sheet. Charge sheet will be normally issued by the disciplinary authority. He will narrate the charges, what are all the charges which are against the misconduct rule number 4, rule number 3, rule number 5, or rule number 13, rule number 16. Whichever is coherent with the charges committed by him, it will be mentioned, everything will be mentioned, and he has to inform to the disciplinary authority about the charges mentioned in the charge sheet within 15 days of time. If the reply is not satisfactory by the disciplinary authority, he will appoint the inquiry officer and presenting officer to conduct the cases, and they will normally issue the orders and where to meet and when to meet and which date, which place, and they will conduct the inquiry. And after conducting the inquiry in depth, the report of inquiry officer will be reached to the disciplinary authority. And if it is proved in the inquiry report that the employee has committed some irregularity or some crime, some act of crime, then the DA disciplinary authority will take appropriate minor penalty or major penalty, taking into account the aspect of the charges. So that is the procedure. In case the charge sheeted employee, he will get the order, punishment order he will get. If he is not satisfied with the order, that his point is not taken into account, then he can make an appeal to the appellate authority within 3 months from the date of receipt of order. And if the appellate authority is also having the same view, there is no compromise review by the appellate authority, and he is standing the same view of the disciplinary authority, then he can go for memorial. There is a 6-month period is there for memorial. Memorial has to be applied to the concerned appropriate authority. We will see the schedule, who is the memorial person for each cadre at the end of this slide. So that's what, like this, the inquiry will go. So after investigation, charge sheet has to be issued. Then inquiry will be conducted. Then punishment will be imposed. Then appeal has to be framed by the charge sheeted employee. Then memorial. This is the flow chart of the inquiry proceedings. This question has been asked by almost 10 years. Every year, alternate years, this question is asking. Mention the correct flow chart of conducting a disciplinary proceedings. The correct proceeding is investigation, charge sheet, investigation first, charge sheet, then inquiry proceeding, then award, there is punishment award, then appeal, then memorial. They will mingle here and there, and they make a 4 alternative questions. You have to mention the correct order of the flow chart of the criminal proceedings, that is domestic inquiry proceedings. So these are all about the inquiry proceedings. Inquiring authority, normally a serving officer will be there. Nowadays, even retiring officer or any other public servant, always one step higher, very important. This has been asked 2 or 3 times. One step higher to presenting officer is normal for making an inquiry authority, inquiring officer. One step higher to the presenting officer. The inquiry employee has to submit 15 days. Another 15 days can be given on receipt of articles of charges, that is charge sheet, and he has to reply. And the inquiry officer has to submit the report. In case of that is will not be conducted even if the employee is superannuated, but to be completed within 3 months from the date of superannuation. Presenting officer to be present the case on behalf of the management in support of articles of charges. Presenting officer and the inquiry officer will be the appointed by management. This defense assistant is appointed by the charge sheeted employee. In order to assist him during inquiry proceeding, he can opt the help of one more person, any even not necessary that junior to him, even a class 1 officer can appoint as scale 4 officer. The scale 4 officer as a scale 1 officer can appoint defense assistant as scale 4 officer to help during the proceedings. No inquiry is needed if they admit the charges only in case of minor penalty. But in case of major penalty, even though he is admitting the charges, an inquiry has to be conducted and proceedings has to be narrated and report has to be sent to the disciplinary authority. If the employee does not appear in person, inquiry authority will hold the inquiry to ex parte. He has to appear date and time mentioned in the notice. If he is not appearing 1 or 2 times, they will wait and give him one more opportunity, second opportunity. If he is not coming, it will be treated as ex parte and proceedings will be conducted without the charge sheeted employee. So these are all this one. Then 27, procedure for imposing major penalty. Employee is informed in writing in the imputation of misconduct, misbehavior. Employee within 15 days has to reply. Communication of orders delivered personally to the employee. So the charge sheet has to be delivered to the charge sheeted employee at any cost, even by registered post, or if he is not accepting the post, put it in the notice board of the office and paste 1 copy of charge sheet at the residence of the employee. So these are all the possible chances of making that employee has committed these charges and he has to acknowledge these charges. And then right of appeal is important. So I have mentioned that time limit for period of appeal is 3 months from the date of receipt of copy of the order. Important, very important question for examination point of view. Appeal, submission of appeal, withholding of appeal by the appellate authority. In some cases, appellate authority will leniently view. The disciplinary authority has not put into his points in the following paragraph, and hence I am of the view that this penalty can be reduced to like this. Like that, he can issue the order, and in that case, the reduced order will be implemented to the charge-sheeted employee, not the original order. Then that is appeal against orders, appeals. Then rigor effect. What is rigor effect? One time this question has been asked. In case the employee is punished under minor penalty or major penalty, 1 year is rigor effect. That is, 1 year he will not get his stagnation increment, which are due, and he will not considered for promotion for the particular year. This is for minor penalty. 2 years for major penalty. 2 years he will not be able to, his name will be given in the debarred list of promotion list by the Vigilance Department for 2 years because of the rigor effect. In case of major penalty, 2 years he will not get the stagnation increment. So these are all the punishments, after effect punishments of rigor effect. That is rigor effect after the punishment has been imposed. 1 year he will not get his promotion, and 2 years in case of major penalty. Third, rule number 39 is the review or memorial, which is normally by the company's higher official, chairman. Company at its own motion can make the review petition and impose the penalty. And rule number 40 says memorial, appeal rejected, and within 6 months he has to appeal to the memorial authority. Who is memorial authority? We will see. So rule number 40 is important. Rule number 39 is review by the management itself. Rule number 40 is important. Rule number 42, interpretations. Interpretations in the CDA rules will be revealed only by the board. And also amendments. Any interpretations, amendments in CDA rules has to be done only by the board. Rule number 42, 43. Rule number 44 says issue of administrative instructions by the CMD. So board has the highly associated authority for interpretation of CDA rule and amendments in CDA rules. CMD can only issue administrative instructions under rule number 44. So this is very important slide. Who is category? The category of employees in the first column. Who is appointing authority? Who is disciplinary authority? Sorry. Who is appellate authority? Who is memorial authority? For each cadre, I have briefly narrated everything. 1 or 2 questions from this slide may come. Last year on questions came. For scale 6, who is the appellate authority? Appellate authority for scale 6 is CMD. Similar question, who is appellate authority and memorial authority? Memorial authority for scale 6 is board subcommittee. For 7, appellate authority is committee, HR committee. Sorry, CMD is for scale 6, board subcommittee is for appellate authority for scale 7 GM, and board is the memorial authority for GM. And one more question, who is the memorial authority for RC, record clerk? One more question, 24. CMD is the memorial authority. So you go through the appointing authority, appellate disciplinary authority, memorial authority. You analyze yourself. Lot of questions may come, maybe around 20 to 25 questions you can create from this. But go through silently, compare appointing authority, disciplinary authority. Normally, see here, an officer in scale 4 is appointing authority, scale 6 is appointing authority. So disciplinary authority is scale 6. Here it is scale 7. So hierarchy is maintained. But see here, appointing authority for senior assistant is scale 5. But disciplinary authority is scale 4. Appellate authority is scale 6. So here it is 1 step lower, 1 step higher. Here, one step scale 4, but discipline authority is scale 3. One step lower, one step, 2 step higher. So like that it will go. But memorial is very important. Appellate authority, discipline authority is also very important. This slide, you should not forget. Memorize this and analyze many questions on this slide. So this is about CDA rules. There are a lot of questions on CDA rules, but because of time restrictions, we will now move to gratuity pension, and then we will come back to the questions and answers. Are you able to see penalties, candidates?
Yes, sir. We are able to see.
Okay. So this is, I have told you, imposing of minor penalty, withholding temporarily for a specified period. This is one example. Withholding of one or more increment temporarily, that is only for specified period of 1 year or 2 years. I have mentioned only for 1 year. Assuming its present basic is 10,000, annual increment is 1,000, date of passing order is 1st January, his normal increment is September 21. Now effect of salary, how it will be affected. So withholding temporarily, present basic 10,000, penalty imposed in 2021. Sorry, this is withholding, no? Withholding. So month of increment is 10,000. 21, he will not get his normal increment because of the penalty. September 22, he will get 1,000 rupees plus 1,000 rupees normal increment, 12,000. It is restored after 1 year. So this is the example of minor penalty. Withholding of one increment for 1 year temporarily. He will not get the normal increment in the particular month, but after 1 year, he will get the old amount of increment plus the new increment, 12,000. This is okay? Okay. Next. Minor penalty reduction for a temporary period. That is withholding of increment. Here it is reduction for a temporary period. Reduction in basic salary one stage temporary for a period of 1 year. Same example, 10,000, increment 1,000, date of passing order 1st January, month of increment 1st September, effect how it comes. Present basic 10,000, penalty imposed reduced. So from the date of order, you have to reduce the basic. Penalty imposed, reduced basic in January as per the date of order 9,000. So 1,000 rupees reduced. Normal increment is in the month of September. Automatically he will get the normal increment. 22, he will get the another 22. His increment is normal. He will get his basic of one stage restored. Here we reduce to 1,000. In the next January, he will get that 1,000 plus this 1,000 normal increment 1,000. So 11,000. From 10,000, this 1,000 will here add. It will come to 11,000. So the impact is only for 1 year. He will not get the increment, either from the date of increment or from the date of order, according to the wordings. If it is from increment date, increment will not be given. If it is from the basic reduced, then it is from the effect of order. So these are all the two changes. This is minor penalty temporarily. This is major penalty permanently, that is withholding of order, withholding of increment permanently. In this case, the same example, but see the effect here. Present basic 10,000, penalty imposed 10,000, month of increment 21, he will not get the increment. So normally, so 10,000 will not be added, 1,000 rupees will not be added. September 22, his normal increment will be given after 1 year. So he is losing one increment permanently here. There, automatically here it will be added. It will be restored after 1 year. But here it will not be restored. He has to forego one increment permanently for 1 year. So this is the effect. See, similarly, the reduction in basic permanently. Reduction in basic permanently means present basic 10,000, penalty imposed 1,000 rupees in the January, so 9,000 will come. Normal increment 10,000. 1 year after penalty, he will not be restored with 11,000. He is losing 1,000 rupees reduction in basic. So this is permanent. This is permanent. He will not get this amount of one increment permanently in the career. So this is the difference between major penalty and minor penalty. Minor penalty, it is only for 1 year effect, but major penalty is the effect is for permanent, entire service. So that is the difference. So this I want to show it to you. We are moving to gratuity, pension, family pension. What is meant by gratuity? Gratuity is a lump sum payment by the employer as a token of recognition of service rendered by him for the past years. And when he leaves the service or dies during service, a lump sum amount is calculated and it is handed over to the legal heirs or to the employee according to the nature of termination, nature of exit. This is frequently asked question. Is there any eligibility criteria for getting gratuity? Yes. Gratuity is payable on the number of years of service with the employer. Any number of years. Normally, it will range from 30 to 40, sometimes 25 to 40, some case 42, some case 43, but it will not go beyond 40, 45. In government service, it will be maximum 40 to 43. Suppose if you are appointed at the age of 19 or 20 and your age is 60, then you will get around 40 to 41 years of gratuity. What is the minimum criteria, minimum requirement of service to get gratuity? This is any eligibility criteria for getting gratuity. Yes, payable number of years of service, minimum required. Minimum, if you work for 5 years, then you are eligible for gratuity. However, in case of death of an employee, after 6 months of service, this condition is not applicable. So remember, in case of exit by death, after 5 years, normally he will get. In case if it is less than 5 years also, the legal heirs will get the gratuity of the deceased person. And if he works after 6 months of service, it will be calculated, but the amount will be very meager amount. According to the proportion, not proportion, some percentage, we will mention the, I have noted the percentage. According to that percentage only, it will be given. So normally 5 years service is required. His gratuity amount will differ on different years of service. Yes, certainly. Following is the chart on number of years of service completed and rate of gratuity. If you complete between 5 to 11 years, 5 years to 11 years, and you are going out of the company, 50% of the last retross basic. Completion of 12, 60, 13, 70, 14, 80. If it is 15 to 30 years, 15 and 30 years, you will get the 100% of the gratuity. So that is differ from years of service. This part is very important. How to calculate as per gratuity? There are two gratuity. Since we are governed by the government and also by the rationalization scheme of the company, there are two gratuity. Gratuity as per Act, and one more is gratuity as per scheme of the company. You have to work out both, and whichever is beneficial to the employee, you can release the gratuity. So first one is gratuity as per Act. Last drawn basic. See, last drawn basic plus DA plus FPA into 15/26 into number of years of service. Maximum is restricted to 20,000. This is first condition for Act. Not more than this. 20 lakhs at present. 25 lakhs central government has made it, but not for our New India and PSGIC company. It is only 20 lakhs. The formula is like this. You have to, suppose if they ask, work out the gratuity, if his gross salary is so and so, you have to multiply 15/26 into number of years. Maximum is 20. How to calculate as per gratuity scheme? This is as per scheme of the Act, the Gratuity Act 1972. This is the formula. But as per scheme, the formula is up to 30 years of service, last drawn basic plus FPA. There is no DA part here. Here only basic plus FPA into 15 years. If you are working up to 30 years, 15. More than 30 years, last drawn basic plus FPA into number of years excess of 30 by 2. For example, an employee has worked 40 years. First, you have to calculate this one. That is last drawn basic plus FPA into 15 years. This will come on amount. Service more than 30 years, that is 10 years. Here you have to work number of years excess 10 by 2, 5. So 5 into this amount will constitute, adding this amount with this amount will constitute your scheme amount. So this is part of calculation for scheme, calculation for Act. You have to work out. Suppose nowadays, if you are on attaining supervision, the retired employee is getting more than the Act amount. For example, for me, Act as per Act is 20 lakhs restriction. But for me, the graduation as per scheme is 28 lakhs. So I got the arrears of 8 lakhs. But the only concern is here. The income tax department will deduct if the payment is more than 20 lakhs. So I have paid 8 lakhs into 30%, 2,40,000 I paid as income tax. That will not come to your hand. So difference between gratuity Act amount and scheme amount will attract income tax. So you have seen what is gratuity calculation as per Act, as per scheme. And the difference is if it is more, if Act is more, you will get 20 lakhs without any deduction. If scheme is more, scheme is 21, this is 20, you will get 21 lakhs. But for 1 lakh, you have to pay the income tax at the appropriate range of tax percentage. For example, I have given here payment of one officer 9940 FPA, date of appointment is 97, retirement on 31/3/23, calculate the eligible criteria, gratuity to the officer. So I have calculated DA also, considering the points. I have calculated the DA also, but in your calculation, they will not give DA. They will give basic gross salary and into 15/26 into 36 only. You have completed years is 36. You have to complete this part and you can calculate. Here I have mentioned basic FPA and I have calculated DA, but in your working problem for the examination, they will not, you need not work like this. They will given the gross salary is so and so. And he worked and his retirement and he aged about 36 years. Calculate the gratuity payable. You have to calculate as per Act. You have to calculate as per scheme. Whichever is beneficial, you have to mention. So here it is 18,35,000. 20 lakhs is payable as per to the employee. So this is 20 lakhs is payable as it is beneficial to the employee. As per scheme, it is coming as 18, but as per Act, it is coming as 30. So beneficial is 20 lakhs, restricted to 20 lakhs. So he will get 20 lakhs. But for SES employee, supervisory clerical employees, this scheme A plus B is restricted to 20 months pay. Here one condition is there for only for class 3 and 4 employee, not for others. For them, the maximum amount as per scheme is 20 months basic, 20 months gross salary, 20 months pay. Here I have given a slide, retirement. how to calculate as per Act for all class same, as per scheme 1 and 2, and as per scheme for class 3 I have given. Death, BRS, resignation. For resignation, calculation as per retirement, gratuity. However, gratuity is payable only after minimum of 5 years of service, not less than that. Gratuity as per scheme. Here also, gratuity as per scheme, minimum 5 years service is required. If they resigned within less than 5 years, they will not get that gratuity. BRS and death and retirement, the three calculations are one and the same for them. So one more calculation for wages, class 3 for employee, that is wages, that is basic DA, FPA. This is for Act. Into number of years of service. This is as per Act. This is as per scheme. First 15 years of service, basic pay into 15 years. First 15 years, then remaining more than 30 years, 15 years, more than 15 years, the basic pay will be divided by 2 and the amount will be added, which should not be more than 20 months basic salary. Not basic, 20 months gross salary. Whichever is favorable to the employee. This is for class 3 and 4. Next is pension. There are several pensions are there. We have the following pensions. One is superannuation pension, that is normal pension for all the retired employee. Pension on voluntary retirement, VRS. Sometimes they will get 100% pension. In some cases, VRS employees will get lesser pension because they have not completed the full service of 33 years. In that case, it will be proportionately reduced. The pension will be proportionately reduced. Then one more thing is invalid pension. Retirement due to bodily injury, mental infirmity, which constitute that he is unable to attend the office. In that case, invalid pension is payable. 50% of the emoluments, minimum 9,000. Then compassionate allowance. In case of charges on the employee, and if it is proved that he has to forgo all the benefits, in that case, the disciplinary authority can consider some compassionate allowance can be given, and we should not exceed 2/3 of the pension. Compassionate allowance to the terminated employee, removed employee can be given. Then family pension. If the employee dies during service or after retirement, family will get some amount of pension according to the percentage of basic, 15%, 20%, and 30%. Now, government, during your wage revision, it will be implemented 30% family pension for all the employees. So like that, it will come. In that case, 30% pension, family pension will be drawn by the legal gas. So there are superannuation pension, voluntary pension, invalid pension, compassionate allowance pension, family pension. These are all the types of pension. So service criteria. For gratuity, minimum 5 years. For getting pension, minimum 10 years. On the date of requirement shall qualify for pension. Here 10, there it is 5. Those who have completed 33 years of service are eligible for full pension, that is 100% pension. Who have served less than 33 years will be given pension on proportionate basis. So that's why we are in the pension formula, we will divide by 33. So they will get proportionate amount. This is important. Minimum 20 years of qualifying service is required to earn pension on VRS. If an employee wanted to go on VRS at the age of, after completing 20 years of service under pension scheme, he can go, he will get pension, but not full pension, only proportionate pension. If he works 33, he will get full pension. Since he worked only 20, proportionate pension will be implemented. So pension for FTS. So basic pension, commuted pension. So the components of a pension, here it is mentioned basic, commuted, and DA for pension. Normally, basic pension constitutes 50% of the average salary received for last 10 months of service is called basic pension. Normally, we will call, suppose your basic is 1 lakh at the time of retirement. I have to calculate the average 10 months basic. Suppose maybe before 3 months, you may got one increment. So 10 months average will constitute 50% of the average will constitute basic pension. Suppose 1 lakh There is no increment. So I will put 1 lakh. 50% is 50,000 is your basic pension. What is commutation? From this 50,000, 1/3 amount you can commute and get a lump sum amount now itself after the retirement. This is not compulsory. If you want, you can commute. Otherwise, you need not commute. But the maximum commutation is 1/3. You can commute lesser than 1/3 also. So this is commuted portion. Suppose if an employee wants to 1 lakh drawing 1 lakh, wants to commute 1/3 of portion, normally he will get around 15 to 16 lakhs as commutation amount at the initial stage itself. But many retired employees will opt for commutation because a lump sum amount is already he is getting in front upfront, and this commutation amount will be restored after 15 years. That is from 65 to at the age of 70, 75, he will get the full pension. So that is one part. This is calculation of pension. 50% average pay for the last 10 months into qualifying service divided by 33. This is for getting full pension. Basic includes, pay includes basic plus FPA, none not other than this amount. 10 months basic, FPA, retired on 31/3, calculate his eligible pension. I have calculated but DA, but it is not necessary. The formula is 50% of last basic drawn plus FPA into number of years of service by 33. Full pension is admissible on completion of 33. If it is 36, there is no need to divide 33. If it is 31 or 32 or 30, less than 30, then you have to divide 33 to allow the proportionate pension. If it is 30, more than 33, you need not deduct. 34, 35, 36 need not deduct 33. In case of death, here for retirement, this is the formula. In case of death, there is no need to take 10 months average. Last basic drawn is taken for commutation plus FPA if it is there. In case of VRS, for VRS, if the employee has 25 years of service and he has sacrificed 10 years of service in such cases, an additional qualifying service notional credit of 5 years will be given if he has completed 25 years of service. So 25 means another 5 years, 30. He will get pension for 30 years, not for 33 years. If he worked for 28 years plus 5 is 33, he will get full pension. If he worked for 26 years plus 5 is 31, he will not get full pension. Proportionately 31 by 33, a small portion will be deducted. Resignation. In case of resignation, the employee will not get any pension benefits. In case of resignation, the employee will get gratuity provided he worked for 5 years. But pension not eligible in case of resignation. So there is a separate formula for retirement, separate formula for death, the same formula for VRS also, but only thing is the proportionate amount should be taken care. These are all other important points. Employee works for 29 years and 6 months. Service will be 29 years only. He has not crossed 6 months. 29 years, 6 months and 1 day. Service will be 30 years. Minimum years of service for pension 10 years. No such limit in case of death of employee. In case of normal superannuation and invalid pension, minimum 10 years service is required. So yeah, so 6 months plus 1 day will taken care as next round of number. 6 months and less will taken care lesser year of service. So this is important point while calculating the pension. So I have calculated one pension, 50% of basic plus FPA into 36 years of working by 33. So amount is 5988. This is the basic pension plus DA, applicable DA as per the point, as per the slab. Now you have worked out for you. The only difference is for serving employee, the DA is payable every quarter. For retired employees, the DA is payable once in 6 months. So that is the only difference. Other thing is same. Serving employee will get 3 DA difference 3 times. No, not 4 times each quarter. But retired officials will get only 2 times in a year. Normally, I think January, February, and July, August. So like that, they will get the revision in DA. Commutation of pension. See, 1/3 of I am working 50,988 basic. 1/3 of this is 1/3 of this into 9.81 is the factor for the age 61. Because you have completed 60 by the time of retirement. Next factor is 61. For this, it is common 9.81 into 12 months. 20 lakhs is the lump sum commutation amount. Balance pension after commutation, that is 2/3 of this amount plus DA applicable for the whole amount, not this amount. The whole amount, not 1/3 amount. Whole amount DA will be calculated, but only 2/3 it will be added 57,977. So this is basic plus DA. It will come around 60 or 70 something. If same DA, it will be around 73,985. Here it is coming 57,977 after commutation. So this is the only difference. Family pension. In case of employee died during service or at the time of after retirement also, the family will get the family pension according to the schedule. Normally, the spouse has the priority, immediate nominee for getting the family pension. If spouse is not there, dependents, unmarried daughter, unmarried son is the concerned dependents for receiving the pension, family pension. In case some disability son or daughters are there and they are permanent, since they are permanently dependent on the employee and spouse, they will get until their death. So this is the provision given under family pension. Spouse, children, parents. Suppose children is not there, a young boy around 33 years died. For them, only the dependents are parents. They will get the family pension. There are 2 concepts under family pension: normal family pension, enhanced family pension. This will activate when the retired person's age is less than 60 and he attains the age of 65. So like that, the enhanced family pension will come. The basic DA is same as for a serving employee, 0.08% of basic. So this is the calculation of family pension. Up to 15,950 basic, 30% pay plus DA. 15 to 31, 20% of the pay plus DA. Above 31, 761, 15% of the basics plus DA. This is as per the present condition. It is going to change for all the category directly basic into 30%. Last drawn basic into 30%. Like that, it is going to come in the next wage revision. So some aspect additional family pension, enhanced family pension, not so important. They have not asked. I have worked out one example of family pension. A person died and he got his pension is around family pension plus total amount is 15,703 and he get twice the rate. And how the family pension is calculated. So I have made one example for assistant manager and another example for assistant, another example for development officer grade 1. I will share the slide through the person's coordinator so that you will go through the entire family pension and everything you will come to know. So these are all about family pension. Some more points. Okay. Any doubt on this CDA, gratuity, family pension? I will give you time 10 minutes. Then we will break up for tea for another 10 minutes. Then we will go through for the mock test paper, because if you complete more mock test papers, it will be good for answering the questions at the test easily. They have not asked to calculate the family pension like that. They have not asked for the past 15 years, but they asked to calculate the gratuity as per Act, calculate the pension. They gave the basic plus FPA and the number of completed years they gave, calculate the calculate the pension. Suppose if it is less than 33 years, you have to proportionately give the pension. Calculate the commutation amount, maximum 1/3, you can calculate 1/3. So like that, you can work out this one. So I have given some examples also, just to go through this. Any doubt?
Sir, can you briefly explain that procedure for major penalty once again? Bit confusion was there.
Big confusion. Okay. Major penalty means on seeing the charge sheet itself, the charge sheeted employee come to know whether it is a minor penalty or a major penalty. Or the disciplinary authority will also issue the charge sheet like this only under major penalty order, major penalty charge sheet, RJD, major penalty, RMJ, like that they will mention. Minor penalty means they will mention the minor penalty itself, because the committed offense is such that it will attract only minor penalty. The committed offense is more, it is a very big one, so that the employee, charge sheeted employee should suffer a major portion of the charges, punishment. In case of major punishment, normally investigation by vigilance officer, he will submit the report to head office. Head office, HR department or IT department will nominate a disciplinary authority, and the disciplinary authority will issue a charge sheet directly to the charge sheeted employee by post, by registered post, or serving by the divisional office or regional office. He has to accept the division charge sheet and acknowledge it within 15 days. He has to reply to the charge sheet why he is denying the charges, and it has to reach the disciplinary authority. He will go through the reply. If he is not convinced by the reply, he will issue the charge sheet, and he will make an order for an inquiry by appointing an inquiry officer and presenting officer, and this procedure will be informed to the charge sheeted employee. So after that, inquiry and the presenting officer will call the charge sheeted employee at one nominated place with giving date and time, with giving sufficient time of 1 week or 10 days or 15 days, and they will conduct the proceedings. So what are all the charges? Have you received the charge sheet? Are you admitting the charges? Like that, the inquiry officer will ask. The person will tell, yes, sir, I am admitting out of 3 charges, I am admitting 1 charge, but I am not admitting the charge number 2 and the charge number 3. So I am not admitting. Like that, if he told, you have to record it. Inquiry officer will record it, and the charge number 1 is accepted. So it doesn't warrant any future proceeding. Charge number 2 and 3 warrants further proceedings. So next hearing date will be fixed, and documents will be shared to the charge sheeted employee. Why the charges are, why they have made the charges of 2 and 3, and it will be shared. All the documents, evidence will be shared to this one, and witness, management witness. And if the employee wants his witness, charge sheeted employee wants his witness also, he can bring it and produce before the inquiry officer. And a major sittings of 2 sittings, 3 sittings, 4 sittings, in case of very big major charges, it warrants some more months, maybe 3 months, 4 months, or 5 months. And finally, the inquiry officer will complete the report, and he will submit to the disciplinary authority mentioning charge number 1 is admitted by the charge sheeted employee. Charge number 2 and 3 has gone proceedings, and what are all the charges, why it has been proved, what are all the evidence, documents proved, proving the charge number 2 and 3. And he finally made his point that charges are proved or charges are not proved. After going through the report, the disciplinary authority will send a report to the charge sheeted employee. This is the report I have received from inquiry officer. I need your observations, or I need your confirmation of receipt of these charges and your reply. So charge sheeted employee will give again reply. No, I have given all these documents, but he has not taken into account. He has not taken my witness. Everything, so small things he will blabber this disciplinary authority. And finally, the acceptance of reply is left to the discretion of the disciplinary authority. And if he convinced that charges are proved, he will impose the penalty, and he will issue the orders to the charge sheeted employee, either through the directly by registered post or through by the divisional office, regional office. So this is the charges, and from that date, the penalty has to be imposed. he will find whether which is a major penalty or minor penalty, withholding of one increment, demotion from assistant manager to AO, like that, or termination. Everything they will be mentioned. In case of termination only, disciplinary authority cannot sign the order. Appointing authority has to sign the order. In case of AO, who is the appointing authority? DGM is the appointing authority. Suppose in this case, disciplinary authority is chief manager. So this order has to be, termination order has to be signed by the DGM, so that there will not be any flaw in conducting the proceedings. Even if he goes to the court of law, whatever we conducted is as per the natural justice, and a lot of natural justice proceedings has been given to the charge sheeted employee, and court will convince that it will be conducted as per the quasi-judicial procedure. So this is the procedure of major penalty. Yes, any doubt?
No,
But
sir,
it is a major procedure. No, 6 months. In some cases, it may take 8 months or 1 year also. The employee will not cooperate. His defense assistant will not cooperate. He will go for promotion test. He will go for, he will fell on sick. So normally they will dragging the cases. But for this only the subsistence allowance will be reduced after 6 months. If it is dragged by the employee. If it is dragged by the management, employee is suffering. In that case, the amount will be increased 70 to 75%. Okay. Any other question?
Sir, who is the authority for suspension, sir?
Authority for pension.
Suspension.
Authority for suspension, I have told appropriate authority is the person for suspending the employee. Appropriate authority means the disciplinary authority. So I have shown on slide, no? So I have shown that slide is in the another this one. The schedule of who is the appointing authority, who is the disciplinary authority, who is the memorial authority, who is the appellate authority. In that I have mentioned disciplinary authority. So he is the correct, he is the appropriate person, authority for suspending the employee. He will issue the order or HR department to make suspension of the employee. Based on that order, DM can issue suspension order, or directly suspension order will come from the disciplinary authority. Only thing in case of termination order will be signed only by the appointing authority. Who is the appointing authority? He has to sign, not by the DA. If DA is the appointing authority, then it is okay. If he is not the appointing authority, it has to go to the higher person, and he has to sign the order.
Thank you, sir.
Yes. I expect lot of questions on CDA rules. So I have shown you punishment imposing of major penalty, minor penalty of withholding one increment 1 year, withholding of 1 year, reducing the basic to 1 year. Just to see the calculation. For temporarily, it is 1 year means minor penalty means it will be recouped after 1 year. He will be deprived of only one increment for 1 year. After that, he will get that increment also additionally, prospectively. But in case of major penalty, withholding permanently, he will lose the increment permanently. So that is the main difference. So according to the financial irregularity done by the officer or employee, according to the nature, according to the severity of the charges, the DA will impose the penalty, whether it is 4 increments down permanently, 3 increments down permanently, or demotion from deputy to AM, or demotion from deputy to AO, if he is a direct recruitment, if he is a direct recruiter officer, or if he is a promotee officer, he can be a senior assistant to assistant. So like that, demotion can be done. So these are all the major penalty procedure under CDA rules.
Sir, what do you mean by reduction in time scale?
Which one?
Time scale reduction. Reduction to time scale, like one word is there.
Time scale.
Lower time scale. Sir.
Okay. Have you seen the our basic structure, basic pay structure?
Yes, sir.
So in that, I will take that in my book. Suppose each stage will constitute a different increment date. For first up to 5 years, 6 years, increment will be around 1,000 rupees. After that, it will be 1,500. After 4 years, 5 years, it is 2,000 rupees. So this is one time scale. One time scale means up to 1,000 rupees increment is one time scale. From 1,000 to 1,500 increasing, no, that 4 years, that is another time scale.
Sir. Yes, sir.
And lowering from one time scale to another time scale, even you can, from top scale, you can reduce him to a lower scale. That is 2 stage lower in the time scale, 1 stage lower to the time scale. So like that, the penalty will be imposed. Normally they will, if it is decrement from the present basic to one increment, it will be cut. Like that will be done. If it is a major punishment, time scale means from major, he is drawing around 1,000 rupees, 1,000 to 1,100 rupees basic. It will be reduced to 55,000 rupees, 60,000 means. So time scale is 2 time scale is reduced. If you see the time scale, pay structure, starting from 45,000, then 1,500, 4 years, up to 55,000, then 2,000, up to 70,000, like that it will go. That is called time scale.
Sir, thank you, sir. Noted, sir.
Yes.
Period of
So the-
suspension
what
is
is
considered in
this,
terminal
recurrent
benefits.
Yes.
Period of suspension will be considered in terminal benefits as a reduced in service, like.
Definitely, I have told you, no, LOP and suspension. If he is punished by charge sheeted employee has been punished by the disciplinary authority, then those suspension period will not constitute a continuous service. Suppose on the contrary, if he is not punished, he is not guilty, he is found not guilty in the punishment, then in that case, his subsistence allowance will be given fully and this suspension period will be revoked and it will be treated as continuous service. If he is not found guilty by the DA, disciplinary authority. If he is found guilty, then he has to, it will attract punishment also, lowering of increment, lowering of time scale or lowering of lower post. And additionally, this suspension period will be a break in service.
Okay, sir. Thank you.
Sudhakar, sir.
Yeah.
So, one doubt regarding this payment of gratuity. It is still that 5 years is the minimum service. Whether any like any change is there, like 4 years to 40 days, some gap is there, wherein we can claim for 5th year. So there was this. There is labor code change, of course, but in payment of gratuity act itself, whether this loophole is there, like you need not complete 5 years, 4 years and 240 days is enough.
Okay. That part, actually, it was in the central government, it was there. Period more than 240 days is completed, it will be treated as one full year. Even for us, for calculating the gratuity, 32, I have shown you the slide, no? 32
Yes,
years,
sir.
6 months, 1 day will be constituted to 30 next year, rounded off to next year.
Yes, sir.
Even for completion also, if he worked for 4 years, 8 months, or 4 years, 7 months, or 4 years, 6 plus months, 6 plus days, 6 months plus days, it will be constituted as 5 years. We can round it. We can round it off. But 4 years, 5 months will not be constituted as 5 months.
Okay, sir.
Okay.
And sir, these changes, I think the payment gratuity act is now amended, I think. this
Gratuity Act is
1 year.
amended as 25 lakhs for the central government employees, not for the public sector employees. Even as per Act, it is our amount is only restricted to 20 lakhs, not 25 lakhs. But why they have made increase only for central government employees? No, they have not a separate scheme gratuity, but we have a separate amount of gratuity as per scheme. We have two options. One is Act, another is scheme. If scheme is more, you will get scheme amount. If Act is more, you will get Act amount. But there is only one concept for all central government employees as per Act only. So that's why they increased from 20 lakhs to 25 lakhs from, I think, last year, 24. From the year 24, they increased to 25 lakhs. That amount will not attract IT also. That 25 lakhs will not attract
this
IT.
choice.
Yeah,
We have this choice available. Right.
Yes,
Okay,
yes,
so
yes. Okay.
thank you.
Any other doubt? You will get 2-3 questions on payment of how gratuity will be calculated. For calculating as per Act, mainly they will ask only as per Act. You have to add basic, DA plus FPA. They will give the formula. They will give the formula confusing with each number 1, 2, 3, A, B, C, D. Confusing formula, but the correct formula is basic plus DA plus FPA into 15/26 into number of years of service. Why 15/26? Nobody has asked. Why the complicated calculation of 15/26 is coming in gratuity, not in pension?
Working days 26, sir.
No. Now, are you working for 26 days?
No, sir.
Are you? How many days you are working?
22.
Oh, 22. But actually, it should come to 22, no? So
Yes,
this is
sir.
the problem. Again, this is the problem in Act. You are working for 5 days, but not. But as per Act, it is for the entire India. One company is working for 5 days in a week. Another central government office is working for 6 days in a week. So that's why they made it common for 15/26. Only Saturday, Sunday is holiday. So the balance balance number is 15/26, not 15/22. For company-wise, it is a common for all employees working in India. So that's why the common formula is 15/26. Right. Good. Any other doubt? Pension. Pension, there is a separate formula. Pension, DA, you will not calculate DA while calculating the basic pension. Basic pay plus FPA. Basic pay, not basic pay plus FPA. 10 months average basic pay plus FPA, very important. Note down, there is a difference between gratuity calculation and pension calculation. For pension calculation, basic plus DA plus FPA. For pension, 10 months average basic plus FPA into number of years of service. While calculating the number of years of service, 6 months plus, we can round it up to next. Less than 6 months, we can round it up to the lower number, rounded off number. So that concept is there. One more important point is pension. While calculating the pension, you have, for getting full pension, you have to work for 33 years. So number of years divided by 33. If you work for 30 years, 30/33 will be a proportional amount. If you work for 36, don't put 36/33. You put just 33 only. Maximum pension is 33. So that is the part of amount. An employee working for 20 years can opt for VRS under pension scheme. In that case, he will get the pension, but only a proportionate pension. He will get an encashment amount at the time of, what is the basic at the time of VRS. Okay. If there is no questions.
Sir, so can you bring the slide to this gratuity slide where the scheme write-up was there?
One.
So next.
gratuity as per act, gratuity as per scheme. You have this one, no?
In that above the formula, there was written something half of these basic was written actually.
Here, gratuity as per scheme, there are two components. One is A, another is B. For A, you have to work. You are calculating up to 30 years. Up to 30 years means it is reduced to 15. That is 30 by 2 is 15. Basic plus DA into number of years is this one. Then more than 30 years, it is deducted by 2 again. That is, he worked for 36 years. See, here is 36 years. So 6 years by 2, the same component. Amount is B is 3 lakhs something. So total is A plus B, 18 lakhs is coming. So you have to add A and B. This is up to 30 years. This is more than 30 years. Even for more than 30 years, you have to deduct by 2, basic by 2. That is number of years by 2. Okay.
Sir,
Here
here it is restricted to 20 lakhs as calculated as per the act. Now, as per the scheme, suppose if this amount exceeds, say instead of 18 lakhs, if it comes to 22 lakhs, so which amount will be paid?
22. Whichever is beneficial to you.
Okay.
You calculate act as per scheme. Whichever is beneficial to you, company will provide this amount. But only thing is the amount exceeding 20 lakhs will attract IT, income tax.
Okay.
Okay. If there is no question, we will wind up for 10 minutes for break of tea because I need some drinks, hot drinks, tea or coffee. Okay, we will start after 10 minutes. We will continue the mock question paper. Then you will find a good script of confidence by writing the examination or writing the examination. Okay, we will meet after 10 minutes. Now time is 3:50. 4 o'clock sharp we will meet. Can we start?
Yes, sir.
Okay. This is previous year questions which were asked by various years, and I need help from the candidates. Read first question, read the option, but read the questions carefully and spell out your answer. Why that is the correct answer. You have to mention. We will go one person by one candidate by another candidate. There is no need of scale 1, scale 2, scale 3. Give chance to everybody. I need voluntary to start the question. Is it visible to you? Is the screen visible to you?
Yes, sir. Visible, sir.
Yes, sir.
Okay, okay. Read the question, spell out which is the correct one, why it is correct. If there is wrong answer, no need. I will explain to you, or some others can explain which one is the correct answer.
D.
Okay.
Last one.
Oh, what's your name, sir?
Surya Prakash.
Okay, okay. So the maximum amount of gratuity payable to an employee working in SCS cadre. This is not an officer. This is not an officer. SCS cadre. Gratuity as per Act. Gratuity as per scheme applicable to SCS. Either A or B. Either A or B, whichever is beneficial to the employee. Okay, this is the correct one. D is the correct one. But only additional point I want to emphasize here is, even though it is A or B, the maximum amount is restricted to 20 months of his gross salary. So that is the point under scheme for SCS cadre. This is not for class 1 cadre. Class 1 cadre, there is no restriction. Even if you get 45 lakhs, company will get 45 lakhs. Even if it is 55 lakhs, there is no need to worry. There is no cap in scheme. But there is a cap for SCS cadre. So that is the negative point on gratuity of SCS cadre. Okay. Okay. Second question.
Sir, can you please repeat once again, sir?
Which one I have to explain?
Yes, sir. SCS cadre and officers cadre, the limitations you have.
SCS cadre, the gratuity as per scheme is, for SCS cadre, it is limited to, even though it is A plus B. A is gratuity, B as per scheme, it is 2 parties there. You have to add the 2 part. That 2 part should not exceed 20 months of his salary. That is limitation for SCS cadre. But for class 1, there is no limitation. You have to add A plus B. If it comes 28, you will get 28. If it comes 35 for DGM, even if it is coming for 45 for GMs. So company will give 45 lakhs gratuity, but the thing is 45 minus 20 will attract IT. There is no limitation in scheme for class 1, but there is a limitation of amount in SCS cadre. Okay.
Yes, sir.
Okay.
Thank you.
Okay.
Sir, limitation amount is 20 months of the gross salary.
Yes, 20 months of the gross. Second part. Second question. So the questions will be like this only in your examination. You have to read the question well. You have to read the answer. Which one is closely associated with the question?
HRM, sir.
Answer D, sir.
No. You have to read the question first.
Which one of the following factors?
Sir, D, both B and C.
D, sir. D.
I want the help of one person, but you have to read the question first. Then only I will allow you to answer the question.
Which one of the following factor not taken into account while calculating gratuity as per the scheme?
For class 1 officer.
For class
So
1 officer.
read the question. Taken into account, factors is taken into account while calculating gratuity as per scheme. You have to understand well. You have to understand well.
Yes.
In scheme,
Following
DA
factor is not taken into account. Negative
only
question. While calculating gratuity as per scheme, Which one is not taken into account? Basic, DA, HRA, both B and C.
D, both B and C, because
Both
only
B and
basic
C.
and FPA is
Answer
allowed.
is A. Answer is A. Basic.
The basic is not taken into account.
Madam, which is
Madam,
not taken.
Not taken into account.
Sir, C. It is only B and C.
Sir, it
Yes.
is
B and
C.
C. So
B
correct
and C.
answer is B and C because while calculating scheme, there will not be any concept of DA. Even HRA will not come for Act also. For Act, only basic plus DA will come. For scheme, only basic plus FPA will come. Here I have not mentioned any FPA. The part will not take into account is DA and HRA. So correct answer is option D. Okay. Good. Okay. Read the question well. The problem is many of you are not reading the questions one time or two times, three times. Then only you will be able to convince one answer. Okay.
Sir,
You
I
know,
have a question.
one
but
person.
Who
Sir,
is
okay,
the
I'll-
disciplinary authority for scale 6 DGM, and if censure was imposed, within how many
sir.
days he has to appeal?
Sir, you have to read the question. Who is
Question
the
number
disciplinary authority?
Who is
Sir,
the
can you please
disciplinary
read the
authority
answer
for
of-
scale 6 DGM?
Okay.
And if censure was imposed, within how many days he has to appeal to the appellate authority?
Okay.
Sir,
So question is two part. One is who is the disciplinary authority, and other is who is the appellate authority. Okay. Your answer?
One, sir, one. Number one, senior most GM and appeal within 90 days is the answer.
You have not read well. You have not read well.
Three, sir. It is 3, sir. 3, sir. Senior most GM
It is
and
third.
recent circular, sir. What is the answer as per the recent circular, sir?
Recent
Senior
circular,
most GM.
recent schedule. Senior most GM and director. He is the disciplinary authority and appeal provision within 3 months. So that is the correct answer. Not 1, not 2, not 4. Okay. So this is the new concept. It was, I think, 2009, 22 or 23, 21, 22, it was revised. Senior most GM and director and appeal provision within 3 months. So question 3, option is 3. Answer. Next.
Please
4.
tell, sir, answer of second.
Answer is 3, ma'am. Senior
second
most
question.
GM. Second question, you have not. Answer is D, both B and C. D for doctor. Okay. Fourth question, read well and answer correctly. So for scale 3, 4, 4, 5, this type of questions will definitely come. But you have to devote at least 2 to 3 minutes for the question, reading the question. The answer will be very simple, but unless you are thorough in the question, you cannot answer the correct one.
1, 3. That is third answer. Third, option 3.
Option 3.
Fourth question. Option any difference of answer? So time is why 1, 3? That is 90 days, no?
90 days. 3 months.
Yeah. So 90 days, not 3 months. You put 90 days normally, because 3 months means again the problem of 30, 31 will come, no? Put 90 days. Normally 90 days. Suppose if the option there is no 90 days, only 3 months is there, tick the 3 months. But if this is the date answer, no? In case of date answer, you have to be accurate. You cannot put 3 months. Here you have to calculate from 2/12, when 90 days will expire.
3/3/2024.
3/3. You are calculating months.
29 to first one.
29 to the first.
29 to sir.
29 to.
29.
So, sir, whether 2 will be taken into account for calculating 90 days?
You are calculating wrong months. You are calculating wrong months. 1, 2, 3,
24.
not 2.
29. 1 month.
1, 3.
2024.
1/3/2024 is the correct answer.
Yes.
Okay. Okay, not 29/2. It is 2 months only, not 2 months, even not even 2 months.
Sir,
So from
but,
2.
Sir, but in the book it is written 3. I mean the CDA rules. It is written 3 months,
Yes,
and
ma'am.
not
Yes,
in
ma'am.
days.
So I am also of the opinion 3 months. Suppose here the answer, there is no direct answer to click 3 months. No. Suppose what is the appeal period? If they asked the 3 months, 6 months, 1 month, then you can click 3 months. Here specifically, when from which, what is the expiry date to file appeal? Then you have to count now. How to count 3 months? So I put 90 days. So 90 days, one more thing is given 90 days. But which one is the near answer? Even though if it is
from 2nd December to 2nd January would be 1 month. 2nd January to 2nd February would be 2nd month, and 2nd February to 3rd March. 2nd March would be 3 months. So he has to appeal before 3rd of March. No, that is answer 4.
No, 2 to 1. No. 1st March. It will come only 1st March. From starting from 2 has to count. And it is expiring on 30 days will expiring on 1/3. So 1 month, 1/3, 1 second month, 1 to second month, 1/3 is 3rd month. So correct option is 3, 1/3/2024. Okay, next one. Many CDA questions.
Fourth. Answer 4.
Read the question
Answer
first.
4. Major penalty need.
No, I want to read you the question so that
while conducting a domestic inquiry, one of the following rules need not be followed.
Okay.
We just need to know which is need not to be followed.
Answer 2, quasi-judicial proceedings.
That is quasi-judicial, no? It is like court proceedings only. You have to give principle of natural justice, but that has to be followed. My question is need not be followed. Reasonable opportunity has to be given. Fourth one is a major penalty can be imposed without a regular inquiry.
Fourth one, sir.
Without a regular inquiry, you need not impose a major penalty. Okay. 6th one.
The employee shall be deemed to have abandoned his post if he absents himself from duty without leave.
Please read it in your mind. Sir, please read it in your mind and let others also think about the answer.
Option 3, sir.
So there is direct question. This is direct question. Employee shall be deemed to have abandoned his post if he absents himself from duty without leave or overstays his leave for a continuous period of one of the following days without any intimation therefore in writing. If he is no intimation in writing to the concerned office, he is deemed to have been abandoned his post and there is no need to conduct inquiry. This is very important.
180 days.
No, 90 days. Answer is 90 days. 3 months if you are silent, no intimation to the office, you will be abandoned from the post. Very important, but nobody is imposing this. But in CDA rule, it is there. Abandoned his post if he absents himself from duty without leave or overstays. Even if he overstays leave and doesn't seek for extension, then also it is deemed that you have abandoned from the post and you will be terminated automatically. So answer is 90 days. That is correct answer. Very important question. 1 or 2 times this question has been asked. Similarly, okay, that question will come. Okay. 7th one.
Sir, 7th is not visible.
Not visible? Sorry. Yeah. Oh, sorry. Okay. Match the following.
Pension 10, gratuity 5.
Yeah, pension.
PF
Sir,
PF,
Provident
no,
Fund. Provident Fund. No minimum service.
Pension 10 years, gratuity,
Okay. 5 years.
gratuity 5 years, PF no minimum service, EL encashment on confirmation.
Good. Very good. So within this one slide, you got the 4 answer. Minimum period of service for gratuity 5, pension 10. For PF, it is immediate, no minimum service required. Immediately, your amount will be remitted to PF department. EL encashment only on confirmation. Good. 8th question.
Sir, 4th one, sir. Employee pension is not eligible in the case of the following situation. Employee resigned after completion of 15 years.
Good. For superannuation, it is eligible. VRS opted employee is eligible. Due to death of an employee, it is eligible. Only thing is if you resigned, not after completion, if you resigned after 5 years also, you are not eligible. But the only thing I have mentioned some years, you are not eligible. 9th one.
Sir, one question is there, sir.
Tell me.
So in case one employee is resigning after 20 years, whether it will be deemed to be a VRS?
No. You have to mention that I am going for VRS with the following reasons. Then only your VRS has to be accepted by the competent authority. Then only you can go for VRS. If you give resignation, company will accept the resignation, but no benefits will be given. Okay. If you submit your resignation to the company, HR officer, HR manager will tell why you are submitting resignation. You have an option because you are an NPS pension optee. You have the option to go on VRS with completion of 20 years. You can give a letter opting for VRS with giving reason so that the competent authority will satisfy and he will accept your VRS offer. If you put no, sir, I want to go on resignation. Well and good. Company will accept the resignation, but without any benefit of pension. So it is the duty of the HR department to convince the person why you are going for resignation, because the person doesn't know about the pension rules. So, okay, then in that case, I am going for VRS, sir, because some benefit is coming for me. No. So I am rewriting my submission and asking for VRS. He is submitting with reasons. Then the competent authority at head office will accept the VRS by giving notice. A notice has to be given. 90 days notice has to be given for VRS. Then only during 90 days, you should not take any leave. 1 day CL has to be taken, not more than that day. EL, SL, you should not take. If you take that, 90 days will be postponed again. Okay.
But gratuity will be payable in case of resignation. Gratuity is payable.
Gratuity will be payable, but pension is not payable. No. Okay. Correct. Answer the 9th question. Are you okay? No.
Yeah. Yes, sir. Thank you.
Yeah. Okay.
Sir, 1 is the answer, sir. Question number 9. In respect of commutation
Anybody
of
knows
pension.
the answer?
Answer number 1, sir.
Okay. In respect of commutation of pension, one of the following statement is wrong. Okay, it is a wrong statement. Commutation is payable to legal cast. Commutation is payable to the retired employee. Sir. Employee can opt maximum 1/3 basic pension as commutation. Commutation will not attract income tax. Which one is wrong?
Sir, 1 is wrong. Commutation is not payable to legal hair, sir.
Okay, correct. You are correct. But madam is wrong, no? Madam told commutation will not attract. Whether commutation will attract income tax? No. Only in gratuity, the difference between scheme and act will attract income tax. Nothing other than this. All terminal benefits are free from income tax except the gratuity between scheme and act. So commutation is payable to legal gas.
In income tax, you need to show it, but there is no tax on that, madam. Madam, you need to show in the income tax return, but there is no tax on that.
TDS will not be deducted. Will not attract income tax. That's all. Just you show it, so it will be nullified in the income tax returns. Okay. So correct answer is
right, sir. Right.
Sir, now one officer he has committed, so that means the basic gets reduced.
One officer.
Right, sir. But now he opts for commutation. Now the basic
Okay.
gets reduced. Now
Why basic is reduced?
Reduced means like basic will remain same, but he will get
Basic
2/3 of
pension.
that.
You
Say
tell
for
basic
example,
pension.
sorry, not basic pension.
Not basic. Basic pension
Sorry,
will be
sorry.
reduced.
Pension will be
If he
reduced.
opts for commutation, basic 1/3 basic will be reduced. Basic pension will be reduced. So for that,
in the
DA
circumstances, if suppose if the person dies, say immediately fixation of pension if a person dies after 6 months.
Okay.
So while calculating the family pension, whether there will be any impact of this.
Commutation will be payable immediately after retirement.
Right.
Suppose after attaining the age of 60, he is giving commutation. He is giving commutation on the last day.
Right.
And immediately next day, if he dies, then only the cases will come for legal gas. In that case also, the family will get only family pension, not this amount. That is the enhanced family pension is there. In case the person died after 60, this commutation will not be given. Enhanced family pension will be given, but commutation is payable only to legal gas, not to any other person.
For example, if the basic is fixed, say for the purpose of calculation of pension, the basic comes to 90,000 and he commutes 1/3. So now the 2/3 pension, 2/3 basic means it will be 60,000.
Yes.
So for say suppose he retired in December. So for the month of January he receives 60,000 plus GA over that. In the month of February he dies. So in February he dies. So how much is what will be the calculation or what will be the impact on that basic pension for family while fixing the family pension?
No, commutation will not be given to the legal gas. So though he is opted for commutation, he is not able to receive this amount and he died. So that there is a provision of family pension and enhanced family pension up to 65 years is there. The legal gas will get, that is the spouse will get enhanced family pension. Normally family pension will be
30% of the 90,000 or 60,000?
Right. 60,000 in 90,000, not 60,000, because if we are not given the commutation, no. In the 90,000, according to the 90,000, we fix the percentage and we will calculate the family pension. If it comes 8,500, we will double it. 16,000 will be payable to the legal fare up to 65 years. 5 years we will give free. After that only we will reduce to the single family pension.
Okay. Got it.
Sir, sorry. If an retired employee becomes eligible for commutation, but before getting he dies, is it not payable to legal gas? This is amount due to the retired employee, but it has not been paid due to some procedural angle. So legal gas are eligible or not, sir?
No, they are not eligible, sir.
There is a provision in the pension rules. Suppose if the retired employee after retirement dies, then he is eligible the family is eligible for family pension only, but enhanced family pension will be given. There is a provision, not the commutation amount. Commutation is payable only to the retired employee, in the hands of the retired employee, not to the legal heirs are not eligible to receive the commutation. They can get enhanced family pension. They will get double the family pension up to 65 years. 5 years they will get. Okay. Not the commutation of it. Okay. 10th question.
Excuse me, sir. Is the list where when GTIS will play a role, right?
That will give. That will be given.
Yeah. So
all amount will be given to the legal gas.
Yeah. This only the GTIS will be covered in this.
Correct.
Yeah. Okay.
Sir, can you please explain what is the basic idea why this commutation of pension facility is available to us?
Normally commutation is payable only to the retired employee to get a lump sum amount, because from basic amount we are reducing an 1/3 amount and we are paying in advance. Otherwise he will get a full pension, maybe around 70,000, 80,000 he will get. Because of commutation he is getting a full amount that will be taken care for his future investment something. But this commutation, he is giving commutation. After giving commutation, next day he died means the family pension, there is a provision in the pension, the family will get double the enhanced family pension up to 65 years of the retired employee. So 5 years he will get enhanced family pension, not the commuted amount. Commuted amount only it should go to the hands of the retired employee. Okay. Here the possibilities you are mentioning, after giving in commutation, if the employee dies, what is the procedure? No. Even giving commutation, how can I give enhanced family pension to the family legal cares? It should not be, no. Okay. 10th question.
Hello. Sir, still I am not able to understand the meaning of commutation. Like why it is given.
Sir, may I interrupt, sir?
Tell me.
Sir, madam, there was a concept like earlier times, no, when there was a comparison of PF and pension. When PF opti used to get a lump sum amount, pension opti people were thinking that we are not getting any lump sum amount, only we are getting a sum of amount, part of salary as pension. So that was the reason there was a concept came that let us give a commutation, which is like as you are having a total corpus, say it is 3 lakh rupees. At the time, you are given an option either to choose 33%, that is 1/3 of your corpus, to take it as a lump sum. If you need, you can take it. If you don't need it, you can just leave it as it is. You will get it as a pension.
So that is one
right,
part.
sir?
Another part, as per pension provision, if the employee died immediately after the age of retirement of 60, the company has to give double the family pension up to the age of 65 years. Even 5 years we got to give. So that amount is a.
It can be told as such that the employee is considered as alive till the age of 65. The family will be given the pension.
Correct. That's right.
Okay. Sir, for how many years it is commuted? For how many years it is commuted?
Madam, it is a 1 years.
Pardon,
sir? Only
15 years.
Only when employee. Sir, that extended family pension will be given when employee dies whilst on service, no, sir?
No, sir. No, sir. When the employee dies after retiring, after retirement, the employee dies before the age attaining 65. The family will be given the pension
then
as
also
it is alive till 65.
Yes. Two parts. There are two parts. One is alive. Another is retired immediately up to before the age of 65. There are two parts. Okay. So that commutation is payable. The original pension will be restored 15 years after the retirement.
Yes, sir.
So you are at the age of 60, you are commuting. From 75 years, your original pension will be restored. That 1/3 will be also added. Okay. Are you convinced now?
Yes,
Sir,
sir. Yes,
is
sir.
the commutation available after 75? No.
No, ma'am. Only one time. Only one time.
Just wanted to have a clarification, sir. Thank you.
Okay. Right. Okay. No issue. 10th question, we will go just speed because already time is 4:30. We got to see around 100 questions.
When an employee died during service, the minimum years of service required to get family pension is 5 years, 10 years, 1 year. No minimum period of service is required. Option 4, sir.
4, sir. 4, sir.
4. Are you convinced? All of you are convinced? I have told already, when an employee died during service, there is no concept of minimum year to get family pension. Even 6 months, less than 1 year is also proved. Provided here only one part is the report of the medical officer who has seen this person. He is a direct report officer or direct report assistant. We have to see the report of the doctor, whether any negative point has been mentioned in his report. If there is no such negative report, you can immediately grant the family pension. And even though they are eligible, they are also eligible for, they are not eligible for compassionate appointment now, because there is no confirmation. They have not completed 55 years of service like that. So no minimum period of service is required. That is the correct answer.
Sir, what is in the case of NPS?
What is in the case of
NPS?
NPS employees.
Which one? NPS employee, family pension, no? There is no family pension for NPS employee, no?
Nowadays, we all are having only NPS, no, sir. Like the existence of old pension scheme is not available after 2010, no, sir.
We will pray that you will also get, because they are trying, no, you will also get for the full pension, no? 1990 base pension is extended to all others. Many state governments are fighting. I think central government people are also fighting for that. Suppose if it comes through, then it is good. But otherwise, NPS, as far as me is concerned, NPS is not a good substitute for pension scheme. You will get, but how much? When? Whether it is invested in bonds and equity, they are telling. Whether it will yield a good result, we don't know. How much lump sum amount you will get, Don't know. There is no clear democracy about payment of national pension under pension NPS scheme. Okay, we will let us hope for the best. Okay, next one. 11.
One of the following period will be counted as qualifying service while
not be
calculating pension benefits.
Read the question well. Following period will not be counted. Will not be counted. Okay.
Will not be counted as qualifying service while calculating pension benefits.
Sir,
Okay.
deputation to foreign service.
3? Is it
No,
3?
3, sir.
Let-
Military service rendered by employee.
Let her answer it. You just read. You see, the problem is you read the question well. I have given enough time. One option number 1 is period of deputation to service, foreign service. Period of suspension after inquiry, the employee was not plead guilty and was exonerated from the service. So it will not be counted. Third, military service rendered by the employee before joining the company. Military service rendered by the employee before
It's
joining
C.
the service.
Third.
That will not be counted, no. Probation period will be counted. Probation period will be counted. Period of suspension. After inquiry, employee was not pleaded guilty. So there is no break in service. Period of deputation. 3 years he was on deputation to foreign service. It will be counted. Which one is not counted? Military service rendered by the employee before joining. Because 15 years he was in the military. He is getting pension there. Why should I take the service, military service? So when he joined in the company, that amount, the period from that date will be counted for the pension. That is proportionate pension only he is eligible, not the full. Suppose if he added military service, he already taken 17 years plus 17, 34 years, he will get again full pension here. Okay, the correct answer is military service rendered by the employee before joining the company. 12.
The foreign service by foreign service.
Added.
Question number 12, sir. While calculating the following benefits, the 10 months average basic pay will not be taken into account.
Sir, request you, please read it in mind. We are not able
Madam,
to read.
sir has asked to read the
Sir
question.
has instructed
No,
to read
sir.
the question. Yeah, he asked to read out the question.
In the mind, madam, please.
No. He asked to spell out the question by or in loudly.
Okay, there is
Madam,
no
it was
confusion,
for
ma'am.
that
You read
particular
out.
question only.
You read out thoroughly on your mind and answer correct answer. Don't be
Sir, the
very
answer
hasty
is
to answer.
answer is 3, sir. Pension in case of
Answer
death.
is 3.
Only
While
immediate basic
calculating
is
the following
considered, sir.
benefits, the 10 months average will not be taken into account. Okay. Superannuation pension, 10 months average will be taken into account. Pension under VRS, 10 months will be taken into account. 2 and 3 will not come. So correct answer is pension in case of death. There is no need to take 10 months average in case of death. Only in case of superannuation and VRS, you have to take 10 months average. In case of death of an employee, you need to take the last month basic pay plus FPA if it is there. Okay. Right. 13. Answer is third, pension in case of death.
Sir, can you please repeat once again? Like pension in case of death, what will be considered, sir? 10 months average will not be considered. Then what will be considered, sir?
So I have told you, no, last month basic.
Last month, sir.
Okay, sir. Okay, sir.
Yeah.
Sir, 3, sir.
So you just see the difference between superannuation and death. For superannuation, there should be a 10 months average should be there because we know that he is retiring on such and such month. Since it is in that case, the amount will be reduced. The basic average will be reduced because before some 3 or 4 months, your basic increment will not be there. So average will be reduced in case of superannuation. But in case of death, it is a sudden death. He doesn't know whether I will death today or tomorrow. So that's why the last basic pay will be taken into account. 13.
13, sir.
3.
HRA.
HRA.
Okay. HRA will not be taken into account. Correct one. Gratuity as per scheme. It is only basic plus FPA. Good. Very nice. Good going. 14. So I have taken entirely gratuity pension to accomplish that, you must get majority of the marks in this section.
Payable to an employee working in scale.
So I think we have seen this now.
Yeah,
I think
same
this
thing.
repeated. Question is repeated. 15. Very simple. Scale 1 to 2.
3.08%.
Correct. Good.
3, sir.
Good. Okay, 16. There is a time limit in the CDA rules.
It is 3 months.
It is 3 months.
Correct. Good. Inquiry officer has to send the report to the disciplinary authority within 3 months. Good. 17.
Little bit down.
Very good question. I have explained to you.
Sir, number 3, sir.
Sir, answer is A. First, when an employee has been convicted under criminal code.
Why? When he is convicted, automatically
Answer is
he is
4.
sent to
Achha,
the
odd
home.
one out. Okay.
It's
Answer
3.
is
It's
4.
3.
It's 3, sir.
25. Rule number 25. Answer is 4, sir.
Suppose when an employee is arrested by police, there is no need to give, that is, impose appropriate penalty to an employee.
4, sir.
No. That is correct. That is
Sir,
correct.
3 only. 3 only we can suspend him if he is arrested.
Yeah. Yes. Good. Suppose if he is arrested, you can suspend him. You cannot impose a major penalty without holding an
Please tell me,
inquiry.
madam.
Yeah, no. Okay, sir. The answer is 3,
Madam,
right?
please tell me.
3. The answer is 3.
Okay, sir.
Okay.
18.
17th answer.
Okay,
3.
please go ahead, ma'am. Okay, great. Thank you.
17 answer.
17 answer 3.
Right. Thank you. Thank you.
Both are incorrect.
Thank you.
Little bit tough question.
Both are incorrect. Both are incorrect.
Both are incorrect.
More than 3
Both are-
consecutive days, sir.
3 consecutive wrong answer. Answer is
Sir,
correct. 4 is
it is
correct.
as per misconduct CDA rules, it is overstaying the sanction leave more than 4 days. 3 for more than, sorry.
Without sufficient ground.
Okay. Yeah.
You have to read the question. You
It's
have to
4.
read the answer. With
One is
sufficient
correct.
ground.
Both are incorrect.
That is without. Okay. Your
No,
misconduct
only one is
without
correct. One is correct.
No,
is
sir.
correct.
No, sir.
Overstaying
Answer
means
is 4.
sanction leave, even
Both
1 day
are
overstay.
incorrect.
Is it not?
Both are incorrect. That is the correct answer.
That is what correct. Yeah.
Overstaying of 5, it will not come. Only 4.
Yeah.
Without
4 is
sufficient
also
ground.
not.
Here I have mentioned with sufficient ground. There is no negative answer without sufficient ground. So both are incorrect. That is the correct answer. Little bit tough question. Unless you read the misconduct thoroughly. 19. Very important question. You have to know the meaning of one leave rule.
The 4th one, what is that? I think that is nowhere we have read.
Anybody knows what is bereavement leave? Anybody knows? I want from you.
Sir, it is that is when if a person is lost, dies, so the family members are bereaved. So
Okay.
that the leave taken on that ground is bereavement leave.
Okay. Any such leave
It is
there?
not there. It is not there.
Not
It is
there.
not there.
So which one is correct?
4.
4 is correct. Unless you know the meaning, you will not be able to answer this bereavement leave. That is, a close family member died in our family. There is no separate bereavement leave. But trade union leave is there, study leave is there, trucking leave is there as a special case. So the answer is 4. Okay, good.
The trekking leave for what purpose, sir?
For trekking.
For suppose some forest officials are conducting some trekking, mountaineering trekking, a special leave provision is there.
Okay, sir.
Okay, right. 20.
1.
The
Answer is
proceedings
one,
of
sir.
minor
Disciplinary
penalty
authority.
can.
Disciplinary authority, sir.
Okay, so I have mentioned the proceedings of a minor penalty. Even if it is not minor, even if it is a major penalty, the initiating person is disciplinary authority only. He has to first send the charge sheet. Disciplinary authority, appellate authority, he can make an order of that is appeal order. Appointing authority is only to issue the order of dismissal or removal from service. 4 is none. So correct answer is DA, disciplinary authority. 21.
Sir,
1 minute.
sir, one small doubt. Sir, one small doubt.
Tell me.
Sir, in appeal, whether the penalty can be further enhanced or it can be conformed to the actual penalty.
Please note, in an appeal, penalty can be reduced or penalty can be improved. This penalty is not sufficient. Withholding of 2 increment permanently is not sufficient because of the severeness of the charges created by the charge sheeted employee. I am ordering to reduce 4 increments permanently. He can give, but in that case, that is the final order.
Okay, fine.
So, like the court order only, no, can be reduced. It can be increased. It cannot be increased, so he can withhold that the order of the disciplinary authorities holds good. Like that also we can tell. Okay,
fine, thank you.
Okay. Who is the dismissal authority?
Appointing authority.
Good. Whenever the word dismissal will come, the appropriate person is appointing, not DA, not regional in charge, not penalty. Maybe in some cases regional in charge will be the appointing authority, but we have to answer appointing authority. Okay, 22. Okay.
2 CMD, sir.
Good. Good going. 23.
So 3 years service as on 31st March of the respective promotion year.
Good.
Fourth one, sir.
Good going. Fourth one is correct one. Confirmation date will not come. Appointment date will not come. 31st December will not come. 31st March is the correct answer. Good. 24.
One C. Transfer to one center to another is not a penalty.
No.
Issuing
one also not a penalty.
Issuing a warning letter is also.
It is a minor penalty, na? It's a censure.
See, there is nothing mentioned about minor or major.
Is not a penalty.
Warning letter is
not a penalty.
That's why I'm telling, read the question. It is not a minor penalty. It's not a major penalty. One of the following is not a penalty.
All the 3 is the fourth one. 1, 2, 3.
Good. Fourth one is very good answer. So issuing a warning letter is not a penalty. Reduction of increment for a period of 6 months. It will not be a penalty as per minor or as per major. Transfer to one center to another center is not a penalty. This is convenience of the management only. But it is not a minor, not a major penalty. So option is 4, 1, 2, 3 are all not. All of them are not a penalty. That is the correct
What
answer.
is 2, sir? I'm not able to understand the 2. Reduction of increment for 6 months. How?
I given only one the answer, no. But whether it is mentioned 6 months, reduction of increment for 6 months has been given the minor penalty or major penalty, no. It is only 1 year. 1 year, 2 year, 3 year. Broken period has not been given. You cannot impose a penalty like this. So answer is 1, 2, 3. Okay, 25.
3, sir.
Good. Blank CR will flow to the reporting officer. That is the correct answer. 26.
25th answer.
2.
Second.
Good. Or 40 months, whichever comes earlier. Good. So this is the one tricky question. 27 is the tricky question. Read well and answer correctly.
What is the answer of 25th?
2, no.
3,
22
sir.
kilo.
No, 25. She was asking 25, sir.
25.
She
no.
asked me 25.
It is 3. Blank CR will flow to reporting officer. You don't worry. These these question papers will be shared to you. Just to note down the number. Don't write the answer. Okay. 27.
26 ka 2. 26 is 2.
Yes. Again, I am telling VRS means you have to count the days. I have told already what is the provision of notice period for VRS. What is the date? Now how many days? Yes, 90 days. Count the 90 days from date of birth, and his date of appointment is this one. Count the date from date of birth or date of appointment?
Date of appointment.
Date of appointment. He wants to submit his VRS. So how many years first? You got
20 years.
You have to know whether he has completed 20 years first. Has he completed 20 years?
Yes, sir.
Yes. Okay. He has completed 20 years. So automatically then he is eligible for VRS. In which date he has to submit?
So he has completed 20 years in 2013 itself. So any day.
No, sir,
Any day.
If he is submitting on 29, no, sir.
Sir, answer is 3. Answer is 3.
3, sir, 3.
93, 2003, 2013.
So 2013 itself, he has completed 20 years, no?
Yes. Question
sir,
is
sir, what is
after.
Yes.
Yeah, for
Answer
dates,
is
I think something.
option of
To
answer.
give him
Option
best
of,
advice, we can consider for like the years of service. 33 years of service, we can check out for it.
no, my question is
No. For submission of via
Full pension.
option in answer is wrong. So you have to mention that 2013.
26 July.
No, sir.
20 years. 20
So
years.
any earliest
No,
date
sir.
can be done after 2013.
Yeah.
Any
27
time he
10.
can submit, no? Anytime.
Any count he can submit. So 27/10/2013 means he can
He's
submit
eligible
any
for
day.
VRS.
Okay. So my answer option is wrong. Okay. But you have to mention that 90 days notice period is there. That is the correct point here. Okay. Wrong question.
Sir.
28.
Sir,
Yeah.
leave rules during
sir.
Sorry,
leave
if he
rules
complete.
during notice period.
Sir, it
Sir,
is
please.
not wrong, sir. He has
Ma'am,
to
one
attain
minute, ma'am, I
either
have doubt.
55 years of age or 20 years of service.
Madam, it is not golden gate. It is a normal VRS. So 20 years are sufficient.
Yes, ma'am. There are two concepts. If you are a PF optee, not coming under pension scheme, you must complete 55 years. Okay. If you are under pension scheme,
he'll be eligible for full pension after 33 years.
1 minute, I will complete it. In the question, I have not given whether he is opted for pension or not. If he is not opting for pension, then 55 years, answer is 27/4/2026 is correct. But my question is wrong. That is, whether he is opted for pension. If he is opted for pension, 2013 he can submit because 20 years it will be enough. No. If I have
No, sir, he'll be completing 33 years in 2026 now. So he'll be eligible for full pension.
No, right? Full pension.
No, in 2026 he'll be eligible for full pension.
But my question is,
as a colleague, I would suggest him to complete 33 years.
Prior to 90 days,
Your question is like that only. As a colleague, you should suggest him to complete 33 years now. Then he'll be eligible for.
My point, you must understand. If he is opting for PF, not pension, then he has to complete 55 years. Then only he will go for VRS. If he has opted pension scheme, then there is no need for 55 years. After completing 20 years of service, then he can opt for VRS. In that case, he will get only half of the pension. Proportionate pension only he will get, not the full amount of pension. Okay. The question is wrongly framed. So that's why you will not be able to convince the correct answer. We will go for next question.
Sir, please, sir, leave rules during.
Actually, in examination point of view, we are not asking another. Actually,
No, no,
nearer to most
yeah, they were,
probable
yes.
answer.
Yes,
In
yes,
this
yes.
27/4/2026 is most probable answer. No, sir?
Yes, 55 years PF opti is the correct answer.
55 years, it is 27/4/2026.
Yes, correct. Okay.
Sir,
somebody
can
has
you please
asked
help us with leave rules during notice period, sir?
Leave rules. There should not be, you cannot grant any leave except CL. 90 days. 90 days is the notice period. During notice period, management will not sanction any leave. If you are under leave for 10 days or 30 days, EL or SL, your notice period will be extended to that effect. Nothing more than that. Okay.
Fine, sir. Okay.
Or you can pay for that much amount.
Yes. Or you can pay. Even you need not give 90 days notice period. You pay for 3 months salary and you can immediately get relieved. But in such cases, you will not get the relieving letter immediately. Once the competent appointing authority will go through your paper and then only they will take action on this paper. Okay, 28, very interesting question.
Question number 3, sir. 3
is the
Okay,
answer,
good.
sir.
I got already revealed to you, but this type of question is, this flowchart is many times they asked this flowchart 1 and 2, 2 and 3, 3 and 4, but not 4 and 5. For these 3 classes, they have asked many times. Okay, next one.
So it's a 3 or 4?
2.
3. If you are not thorough, I will explain it once again.
Sir, it is 1, sir.
Okay, investigation.
Please, sir.
Yes, investigation will be done by the vigilance officer initially. First process is investigation. If prima facie there is any crime committed by the charge sheeted employee, DA will impose the charge sheet. GA will send the charge sheet. After that, inquiry will be conducted by the inquiring officer and DA will issue the penalty order. And on seeing the order, he can make an appeal to the appellate authority. So that is the correct flowchart.
28.3.
So can you please repeat a bit slowly?
Okay.
So please repeat slowly.
Repeat slowly. Okay, whether time is permitting. Okay. First, initially, the vigilance officer will investigate the matter. If he found prima facie there is an evidence that an irregularity has been committed by the charge sheeted employee, he will report the matter to HRM department of head office and DA will issue the charge sheet. That is second part. Third part, inquiry by inquiry officer and presenting officer will be conducted along with the CE, charge sheeted employee. Fourth one is order will be imposed by DA after that. And after seeing the order, if he wants to make an appeal, he can make an appeal. So that is fifth point. The flowchart is correct. Investigation, charge sheet, inquiry, order, appeal. All others are derailed. Okay. 29.
An officer has completed 25 years of age and he quit the company on VRS. His 10 months average basic was 90,000. He wants to commit 1/3 of his basic. Calculate his basic pension. Here in 25 years of age, question of VRS doesn't arise. Sir,
20 years of service, take it as 20 years of 25 years of
Pension
service.
will not be here as he has resigned, so no
in that
pension.
case, it will be.
No.
20,000, sir.
20 years is the eligibility. But he wants to go on the age of 25 years. There is no.
It may not be possible. That is none of the above.
Why? Why none of the above? Why it is not
25 years
possible?
of service, we can consider it as
25 years
of service.
nobody can complete 20 years of service, sir.
But plus he has resigned, so no question of pension.
Sir, don't go practically. The question is there.
Okay.
Just,
Okay. No, that is 25 years of service, not age.
It is 25 years of service.
Question. I repeat.
If it is 25 years service, then 2.
Service. That is service. You read it as service, not age.
Then 2, sir.
Okay.
Sir, this VRS 25 year of service. Why we have not added 5 additional years?
Yes, you can
Yes,
add.
sir. It is 4.
In that
Option
case, it is
4,
none
sir.
of the above, no?
You can add, but what is the basic pension?
Sir, it is A, 45,000.
Sir, here we cannot add 5 years because we don't know about his age. At what age he has given the VRS application? Maybe after completing.
And in that case, we should do 25 by 33.
25 by 33, yes.
No, answer is 20. He has completed 25 years of service. You don't want to need the date of appointment. He has completed 25 years of service. So number of years of service is 25. He is opting for VRS. There is a provision to add 5 years notional credit.
Sir, after 28 years only, no, sir. 5 years, you can add.
No, after 25 you can add. After
No,
25 you
sir.
can add, not 28. You can add 25 plus 5, 30 years of service. So average basic pension into how many years you have to put?
30 by 33.
30 by 33. In that case, 45 will not come, 30,000 will not come, 15,000 will not come, some other answer will come.
4909, 40909.
That none of the above is the correct answer. Understand? Yes, 25 years of service, he is putting his paper on VRS. You can give notional credit of 5 years. So 30 years is the counting service, but the proportionate is 33 by 30. If you put the average 90, you will get around 40,000 something only now. So answer is that is the correct answer.
40909.
50% of the average basic, na? We have to take 50% of the average basic, na? So it will be 45,000 will be the basic.
Yes,
And
but
we have to
basic
do half also.
of 30 by 33 now. You got to put 30 by 33. He will not get full pension. He will get only proportionate. 25 plus 5, 30. 30 by 33. It will be around 40,000 something.
40,909.
Okay, 40,909 is the correct answer. Everybody understood?
Yes,
why?
sir.
There is a problem. I have told if he completes 25 years of service under VRS, there is a provision to add 5 years. 25 plus 5, 30. But for getting the full pension, you have to work for 33. So proportionate pension is 30 by 33 into 50% of 90,000 will come as 40 something, 40,990 or something. So are you understand now?
But sir, he is commuting also.
This type of questions only will come for you. This type of questions will only come for you. Which one? No,
commutation also
they
there.
have not asked commutation. No, calculate his basic pension. That's all. Why you are worrying about commutation?
He wants to commute 1/3 of his
He wants to
basic.
commute. But what is the answer? What is the answer? He wants to commute. Are they asked commutation amount? No. Calculating his basic pension. So this is the confusing part of the questions. Don't work out the
DA will be
commutation.
paid for full basic pension.
Yeah.
Even after commutation.
Okay. Okay. Now understood. Okay. You are undergoing treatment. Okay. 30th.
Sir, 90,000. Sir, 90,000 into 30 divided by 33 will be the answer.
Into 50%.
No, madam, then divided by 2, na? 50%.
50%.
Okay. Okay.
Ma'am, are you okay, ma'am, now? Okay. 30.
Yes, sir.
Within 30 days.
Within 15 days.
Second.
15 days.
It's good. 15 days time. Normally 15 days time will be given. Within 15 days, he has.
We can extend it up to 45
If
days.
he cannot, he has to ask. I am unable to reply your charge sheet within 15 days. Kindly grant me another 10 days. In that case, DA has to give another 10 days. Suppose after that also I fell on sick and I am unable to reply. Kindly grant me another 7 days. Grant him another 7 days also. But after these chances, if he asks another 15 days, no. You have to DA has to answer no. So that is the part of this question because reasonable opportunity has been given. That is the part. First thing I have given. Second thing also I have given. Why for third thing? So 15 days is the correct answer. 31. Very important question. Last year this question was asked.
First.
One. Answer is 1.
Second one is
Two.
second.
Third one, sir. Casually. It is not.
But this is
Second
this
is
is
the
two,
answer. At
sir.
the start
You
of
are
the
not.
month.
Second is the
All
answer.
of you,
Yes.
Second, sir. Answer
all
is
of you are
second.
not familiar with
Yes.
RH. That is why the problem.
Second one is answer. It should be
The
in
first
Yes,
one,
intimation
maximum
at the
RH is
start
I
two
of the
have,
only.
month.
No, how
I
you can
have,
take more than two?
please.
Only
Sir,
two
I have,
answer
RH one
is
can take.
answer is 2 because we have to intimate the
uh,
HR department in the beginning of the year.
Beginning
yeah,
of the
in
year.
the
Yes,
beginning,
correct.
No,
beginning of the academic year, in the January itself, when you receive the number of RH holidays, you have to give to the HR. So and so date was been selected.
False.
Tell me.
No, 2 is correct.
Answer intimation to RH. Intimation of RH to department, HR department has to be given before 7 days, not before 7 days. It should be at the commencement of the year, that is January. Or at least after receipt of RH dates, holiday you will list from head office. On that day you can give, this is my holiday, RH holiday list. That is the correct answer. So this is false. Good. Okay, 31 answers correct. Many of you are doing well. Tell me.
31 answer.
21 answer is
31.
2. Intimation of RH has to be given before the commencement of the year. That is at the commencement of the year. Or after receipt of RH list of holidays. Not 7 days. Not before 7 days. Not,
Sir,
but normally.
all options are false.
Tell me.
All are false. All are false.
No. Why all are false?
No, first one.
What, ma'am?
Only?
Are you not aware of RH rules? Not more than 2. It is correct, no?
Oh, yes, sir.
All purpose RH will be treated as casual leave. Is it not correct? But you cannot avail half a day RH. Is it correct? No. CL and RH can be combined together. I have told already. Okay, all are correct except that before 7 days. That is wrong. That is false answer. Okay. Do you want to close this or you want to see one more question?
Sir.
One more question paper.
Sir, one more.
One more question paper, sir.
One more, sir.
Time is very short now, 5 o'clock.
Sir, anybody wants to leave, let them leave, sir. We can continue, sir.
Yes.
So how many questions are there?
Another 30.
We are ready to sit for another 1 hour.
Yeah.
Right.
Sir, at your convenience. At your convenience.
But sir,
We will see another 10 questions. Up to 5:15 we will see another 5:15. Now time is 5. We will see up to 5:15. Okay. I will share all the questions to you. You can on your own. You can. Many of you are telling correct answer only. Okay. Read the question. First one.
Share the questions with answers also.
Read the question on your mind. Answer the correct one.
Facility has been extended to retired officials to
But
extend the period for
when you see the question, it will be half page.
First one is wrong.
First,
False.
yeah, advance cannot be taken.
advantage.
Can be taken.
State of first retirement solution is objective. An employee or anyone who can evidence.
All other are correct. Only first is wrong. No advance can be given.
Yeah.
Oh, somebody is told 4D. Correct? No, a retired employee along with his family can avail, but not their relatives. It is correct.
That is correct only, sir. Only A is wrong. Advance cannot be taken.
Good. Very good.
Sir, there must be a special mention about the C also. The post-retirement, there is a income tax provision of income tax is there.
Yes. So availed shall be subject to relevant provisions of Income Tax Act. I have just mentioned.
The statement is correct, sir.
Yesterday only I prepared all this question now for you.
This has to be noted by all I am saying, sir.
Okay. Just read the second question. This will be 3 to 4, 4 to 5.
As per the existing practice, officers are shifting their personal efforts in each job, employing within the same only and allowed doing as per the revision limit. Is incorrect.
This is about local shifting. That is one compound is there, flat is there, company flat is there. From first floor you are shifting to second floor. The understanding is from first floor you are shifting to second floor. Or from top floor you are shifting to first floor.
The last option, sir. Next option.
The shiftings are limited to 20%.
Sir,
What is
option
option
D,
4?
sir.
Option 4.
No,
Option
what
Sir,
is the
question
option,
is not
sir?
visible fully, sir.
Not
Yes,
visible.
yes,
Option 4 not
Not
visible.
visible, sir.
Limit prescribed is excluded. No. D.
Sir, 4 is the answer, sir.
Fourth is correct.
Very good.
Fourth is
Very
incorrect.
good. So you are
D.
correct. 4 is it is inclusive, not exclusive. Okay. The limit prescribed is inclusive of packing, loading, transportation, not exclusive.
Revised specific
This is wrong. 13,000 is correct. Part-time sweeper. Somebody told 50,000 for officers. I have told 45. But this is correct one. 13,000 is correct.
D. Sir,
Okay.
option is D.
D, correct one. 13,000 or 1 month basic on proportion pro rata basis, whichever is less.
Yes.
Option is third option is D. D for doctor. Fourth one.
minimum.
Option B, sir.
Graduation. B.
Option
B.
B. Good. Correct. It was previously it was +2, 10 + 2. Now it was 2 years back they revised, not 2 years, 4 years back revised to graduation.
So none of the above. D.
None of the above.
Good. Yes, all are misconduct. Good.
A1.
D.
Read the question well.
This
Statement is
D,
not
D.
common.
Base
One
date
of the
for
following is
consideration of
not
seniority
common.
marks.
Yes, yes.
Acha, acha.
Seniority mark 31st March. Here it is 31st December. Good. D.
6th
Yeah, yeah.
A.
Seniority.
6D.
Base date.
D,
Okay,
D,
okay.
base date.
T, yeah, sir. Base date.
So what do you mean by base date?
Base
For
date
officer
means,
cadre, it is 31st March.
March.
SCS
For
staff,
class
it
3 it is
is 31st December.
So this is not common. All others are common. There are 2 channels. 1 year they will not be considered for promotion, and technical qualification scale 1 to 2 is given, 2 to 3 is given. For SCS, for all class 3 employee, technical qualification mark is given. 7th.
B is the answer, sir.
No, sir. One. A is the correct
A
answer.
is correct answer.
A is the correct
Not
answer.
correct.
Correct.
A is
I have told correct.
22nd,
A.
6, 2000 it is. not
Yes,
confirmed.
good. Good. 1 is
Oh, it is
correct.
22/6/2000.
It
Sir,
is
B is
correct.
the
A is
answer.
correct.
Sir.
Okay.
Sir,
8th
date
one.
is 20,
Sir, what-
22nd
Sir,
of June, no? Not
sir,
20 June.
Which one? 20?
Yes. So what about option D,
22nd
sir?
June it is.
22nd.
correct, sir. 21.
Okay.
Yes.
Yeah, corrected 22nd. But with my remembrance, I told it is 22, 20. If it is 26, 22, corrected 22. Okay. 8th one. Stagnation increment. Which one statement is correct or wrong? Incorrect statement.
It is not payable to all employees, RC and
Yes, good. That's why. Incorrect statement is it is payable to all employees. It is not payable to RC, and even scale 4 is
Scale
not
3
there.
and
Scale
above
5
also.
is not there. Good. Yes, calculate.
So is it none
Option
of
B
the
is correct.
above?
Option B.
None of the above.
Good.
Yes.
Very good.
It is coming 10,185.
Yes, sir.
Sir,
Okay.
it
Correct.
is-
Correct.
Yes.
So 14,435 into 0.08% into 882.
So
That is
it
the
is
answer.
prior to 1st of August 2022. So 10 will be there, no, sir?
No, effective from 1/7/2018, no scheme. DS lab, it is 21. DS lab as on 31/12/21 was 882.
Okay, okay, sir.
Okay. 10th one. Very important question. Pension.
Here, actually, for 9th question, it's 12731. Please the option because it
Sir,
was
option
21.
A, sir.
Option A,
Option A, sir.
4953.
What is the calculation? 50% into?
Nothing, because 34
Nothing,
years
sir,
are
it
there,
is
na, so we
12.
need not to do anything.
Okay.
Simply divided by 2.
Okay. Good. So now you are well versed, no? Okay, 11th. We will go 11th only. 11th. We will close this. Which one of the following is not a major penalty? Not a major.
D. Reduction without any cumulative effect.
Okay.
Yes.
With cumulative effect. That is major. Not a major means without. Good. Reduction to a lower stage in a time scale, it is major. Removal from service, major. Compulsory retirement, major. Reduction to a lower stage in time scale without cumulative effect means minor. With cumulative effect means major. So answer is only one word, without. Okay. How you feel after attending all these questions?
Very good, sir. Thank you.
Do you have the confidence now?
Yes,
sir.
Yes, sir.
Yes. But
So
this
please
is not
explain fourth point in detail of this last question.
Last question.
Without cumulative effect.
With the cumulative effect is major. So I have told without. I have mentioned without cumulative effect that it is minor. So a question is not a major. So this is the correct answer. D is the correct answer.
Means his salary will be back to the same stage in due course of time.
Which one, ma'am?
Last
Yes,
point.
madam.
That is what it is not a major penalty.
So one thing I want to ask more.
Yeah, tell me.
If he is on a third stagnation and he will be penalized for 2 increments.
Okay.
In case of minor penalty, what will be the repercussions?
Minor penalty, stagnation increment, no?
Yes.
2 increment. He will be immediately from third stagnation to first stagnation. He will be brought. And after 2 years, it will be retrospectively given effect. Only 2 years or 3 years, he will not get the increment purpose. For LTS purpose, for mediclaim purpose, or for encashment purpose, his increment will be reduced. After 3 years, it will be restored. That is the concept
can it be
of
told that his salary is reduced just for the 2 years?
Yes.
And in case of major penalty, he has to wait again for 3 years.
Again. No. That is not there. Again.
In case of major penalty.
In case of major penalty, normally, if such being the stagnation cases, they will not. They will see the repercussions of the stagnation, and they will not impose major penalty in those cases. They will impose some other penalty of major, some financial amount, 2 lakhs, 4 lakhs, 5 lakhs he has to pay. Like that they will mention, because the person may be at the time verge of retirement. You are selling that 3 stagnation increment. He may be at the time of at the verge of retirement. So there is no need to reduce such a huge amount. So in that case, what they will do, they will remit an amount of 5 lakhs or 7 lakhs or 8 lakhs. So that will suffice. They will not reduce the increment permanently. Okay. They will not.
So one more query, please.
Yeah, tell me.
Sir, if the employee has opted for commutation at the age of retirement, superannuation, and then he died at the age of 62, then his family will get double pension or not?
He will get
up
from
to 65.
60 to 65, they will get the double pension.
Even he has commuted earlier, or
yes,
he
has received the amount. It is not for the whether maybe family is engaged, family is benefiting by the commutation amount, but he received already the commutation amount. So because the remaining period is only 3, for increased family pension, he will get from 62 to 65. 3 years he will get.
Thank you.
Okay. I think.
Sir,
yes,
only hypothetical argument. Sir,
tell me.
This commutation alone. Sir, immediately within 10 days, he has received the commutation. Okay. Assuming that, just for argument's sake.
Not
in
10
that
days.
case, he
next
will be.
day.
No. In that case, he will be provided a extended pension, family pension, no, sir?
Yes, definitely. If he received, automatically he will get.
Then
Family
there will be some kind of mismatch between the person who has not, due to some procedural lapses. Once it is become payable to employee, it has to be given, not that kind of argument.
He doesn't know when he will die. No, it is an accidental only. It is an accidental only. So we should not penalize that you should pay back the entire commutation amount like that. We should not tell no. So there is benefit already given. He has received it. After that, he died 10 days or 1 week or 15 days or 1 month. After that, the family will get the enhanced family pension.
That is for you. That is why for uniformity, once it become eligible to pay due to employee, that has to be given to legal care if it is died. That way, it will not come.
Okay, we will see whether it will like that or not. Okay.
Okay.
I am happy that all of you are very attentive, and I hope and I wish everybody should get 25 out of 25 in HR.
So one more query, please. Sorry.
Tell me. No,
sir, in case of case of minor penalty, rigor effect is for 1 year. It should be calculated from the date of charge sheet or from for promotion purpose or for the promotion exercise he will be debarred.
Penalty.
From the date of receipt of order. From the date of receipt of
if the promotion exercise came later on after the completion of 1 year.
No, there will not be any rigor effect.
Okay.
During this period, during this 1 year, if any promotion exercise comes, he will be under rigor effect. He will not be considered for promotion. Even call for a promotion exercise, he will not be eligible.
Suppose so, earlier question. I got that.
Okay.
So in case of stagnation, I earlier asked. In case of minor penalty, his stagnation will be re-established again. But when will his next period will be counted start? Counting will start from which date?
This is a
for next stagnation.
Question, this is hypothetical question or real question?
Hypothetical.
Hypothetical will not come like that. So while issuing the orders, the person concerned, the disciplinary authority what will be the effect if stagnation has been coming down? Because for after every 3 years, 9 years, he got the third stagnation increment. No, we should not immediately issue permanent. So I told you, no, I have already told some financial amount of 5 lakhs or 10 lakhs has to be imposed on this person, because by reducing this stagnation increment, a financial amount will be given, or they will issue some other penalty, not this one. Okay. Thank you very much, and I wish you all the best. All the best.
Thank you, sir.
Full marks.
Thank you, sir.
Sir, please do share entire PowerPoint, sir. Thank you, sir.
Definitely. I will hand it over to the coordinator. You will receive it maybe in a day or two. Okay. Thank you very much.
Thank you, sir. Thank you very much.
Thank you for the patient hearing.